Let's say
Withdrawal.
you want to withdraw.
Withdrawal.
Withdraw from of his client, he wants to dispose them. Okay, it will be disposed.
Same prayer Milord in item 16.
1-6.
1-6 Milord. That was an AP Milord. He was arrested Milord.
Already arrested.
And subsequently released on bail also. By the law.
Okay.
Item number
16.
Okay, it will be disposed.
May it please the Lordship.
Yes,
Lordship, I beg to mention item number 22, my lord.
22.
22.
Yes.
Can it be taken up next week or some other day convenient to this purpose?
What you have? What is the difficulty on your part?
22, my lord. I mean, difficulty on part of conducting counsel, Mr. A. Ahmed, my lord. Requested to make it there before this court.
Contacting counsel A. Ahmed is out of station.
No, ma'am. He is in Lexington Court Division Bench, court number
The
12.
personal
Yes,
A. Ahmed. Item number 6.
20.
Item number 22. It listed after 2 weeks only.
2 weeks, ma'am. Obliged, Lordship.
Lordship, I beg to mention for listing AV on Friday, Lordship. Just on filed on last week, Lordship. Till then, there no.
Friday.
Right.
Friday, we are trying to list less numbers of matters because we have some. Can it be? Yeah? On 5th, we'll do on Monday.
May it please the Lordship. Lordship, I beg to mention item number 20 of the release.
20.
Or 20, Lordship. Lordship.
It's a criminal revision.
Lordship, the affidavit
You are for the petitioner or for the
for
respondent?
the petitioner.
For the petitioner. Respondent.
I'm for the respondent.
You are for the respondent. You want an adjournment today?
Yes.
Why?
Lordship, the affidavit filed with the respondent, which got it yesterday afternoon. Sorry.
You want to file reply?
Yes.
Submitted by the petitioner for the petitioner that the respondent had already put in a position and they want some more time to file the affidavit reply. The adjournment for today. List accordingly. 1 week will be sufficient or 2 weeks?
Lordship,
You need 1 week or 2 weeks?
after 3.
After 3 weeks?
No, Lordship.
Is there any interim? No.
Lordship, in interim order may be continued.
No, are there any interim? I'm just asking.
Yes.
You know.
Yes. Interim order is. Okay.
Okay, yes.
May I please, Your Lordship?
This stuff will be with some. Yes.
May I please? I beg to mention item number 30, my lord. Can it be after a week, my lord? No interim is there, my lord.
So why you need adjournment today?
Some difficulties, my lord.
30, we have received any?
Did you receive, Miller?
CP is received. So next week it can be free.
Can it be on 6th or 7th?
6th or 7th? Can it be 7, 8?
Deep level response.
My lord, I beg to mention item number 37, my lord.
7, 8. Then list CDB detail.
I beg to mention item number 37. In this case, my lord, I have already filed, my lord, a objection, my lord. Interim bail is there, my lord. That case, my lord. Item 37. So I may be allowed to call this affidavit, my lord.
37.
Yes, my lord.
My lord, I beg to mention 2 regular bail application, my lord. I filed yesterday, my lord. Maybe taken tomorrow or day after tomorrow, my lord.
If
My lord.
tomorrow is not possible, yes,
My
tomorrow
lord.
is also not. If
Only,
tomorrow I give
only for
Monday.
CD. Only for CD, man. I will not pray anything, my lord. Only for CD. Day after tomorrow. Some most urgent case, my lord. If time permits, my lord. Only for CD, I will not press
question
bail.
of time permit is not there. We are trying to list it
Only
on
day
list
after
numbers.
tomorrow. Humble prayer, my lord. Day after tomorrow.
5 on 5th, Monday.
Monday.
Monday we'll do it.
Lord.
Maybe only what? Monday.
Lordship, kindly maybe fix on Friday, my lord.
What is the urgency? No, just tell us.
My lord, urgency is family members problem, my lord.
Yes, family members problem. On Monday it will be listed.
My lord.
Yes, Monday.
All right.
For listing.
Monday.
Well, I bet me certain number 18 melody. This is for their for the them 18.
Yes, what you say? What is the problem?
And today's not today's machinery is not
Who is your senior, first of all?
HR fund.
HR Khan.
Huh.
It is not available.
Not well.
Have you informed the other side, Mr. T. Devi?
No, my lord, I shall inform.
Huh?
No, I shall inform.
Inform Kuribo Didi. The adjournment stating that Mr. HR Khan, the youngest cousin, has some personal problem today. Adjournment.
একটু মাতিব এতিয়া আমি এখন হাইস্কুটি কল কৰি দিয়া
Other side. List of
Mark 439 application matter, and in this matter I was arrested on 29/5 and 64 days behind the bar mallet. It's pertaining to Borpeta PS case number 214/2024. So my prayer, Lordship, at this stage may kindly call for the case diary mallet and a short date if Lordship possible.
Yes.
Otherwise, mallet, no allegation against this petitioner, mallet.
Will be definitely
on
What
21/8 minute
Mallet
will be all right. 21/8 or
14 mallet
1/4.
1/4. DPM. DPM.
CD call for 1.
May it please your lordship. Lordship, this is 439 bail application, lordship, 20 days in jail custody, lordship. Can we come to the FIR that is on page 14, lordship? The case was registered under 108 of BNS, lordship. The no lordship. So for the FIR, lordship, it was not instigated to force her to commit suicide, lordship. May I read the FIR, lordship? It is respectfully submitted that since last 2 years, one Gopal Upadhyay as such and such, Howley regularly harass and threaten my wife, Meena Chetri, wife of Sajid, for cohabitation. My wife did not apprise me for the sake of the stigma in society. Somehow I got the hint of such harassment, so I asked her to disclose it, but due to shame, she could not reveal all. Since few days, the accused person confined her and my minor son and threatened her to have for cohabitation. So she has been compelled to consume poison. So I could come to know that the matter, and on 9/7 she has admitted to Guwahati GMC, but the poison reacts so rapidly in her body, so she could not survive. But thereafter her death, but before her death, she revealed through video call that due to constant torture and pressure of cohabitation, she was compelled to consume poison. On 10/7/2001, she expired at
your lordship may
4
kindly
PM.
come to page 18 my lord. Page 18 forwarding report, last one. But before her death in the hospital, she gave her statement in a video recording against the accused, the present petitioner, my lord. In the hospital, my lord, he gave a statement.
But that was not immediate instigation to commit her
Yeah,
death,
this
lordship.
is very
She
much
has
important.
asked for, lordship,
I mean,
cohabitation.
the
lordship.
other merits of the case, but if you go by the FIR itself, it's seen that on the day of incident, she was confined and compelled to have a
Then before that, lordship, that day, no, lordship, day before, few days ago, lordship.
proximate cause of her suicide may be there. That only. Okay, we have.
There's not immediate instigation. There's no this petition. If we assume, lordship, is a feasible of the FIR, lordship. If it is a compel for the cohabitation, lordship.
Harassment on her part, so that may be one of the.
But for cohabitation, lordship, allegation is for cohabitation, lordship. It is not that she has been instigated to take, lordship, such a drastic step, lordship.
How we will say that?
But lordship, she has.
One would say that you
But lordship, she has.
Schedule reveal, my lord, schedule reveal everything. my lord.
That kind of thing is not there. Not never.
She was.
call.
She had a, as per,
On 21/8, my lord.
can it be shorter than lordship, already 20 days
Shorter
lordship in
already
jail
on-
custody?
Shorter date.
It's,
Many
it's
other
from
cases are
lordship
already-
Tamulpur, not
He is
far
arrested
away
on
lordship.
11/7, and prima facie there are material proven.
That instigation is not there lordship.
On 14/8, my lord.
14.
14/8.
Obliged.
Met legal lordship. Lordship, 483 application. Lordship, I was arrested on 6/7/2024 in connection with Hazok case. Hazok case number 242 under section 329 or 64 or 62 BNS.
329 pertains to which section? 329(4).
Which is earlier as per IPC 448 lordship, that is 329, and 64 is 376,
Yes.
and 62 is 511 lordship,
64 is 376.
376. Lordship, actual fact of this case is 177.
Your lordship may kindly peruse page 19, my lord. Earlier rejection order, vital page is page 18. Vital page is page 19, my lord. 19. Earlier
The
rejection
order
order.
filed by session just come out.
Yes. Peruse the CD, my lord.
Oh, the force was also there for swearing an affidavit.
Yes.
Due to mistake, the informant has filed this FIR lordship, and affidavit is in page 25 to 27 lordship.
But your earlier petition was also rejected.
Rejected lordship.
Let us call for the case diary, then we don't have any alternative now. See, he is in custody since 7/6 or 6/7.
7/7 lordship.
Huh?
In forwarding actually
7/7.
7.
FIR was lodged on 7/7. When he got arrested on?
Lordship.
FIR was on
On
7/7.
my lord. So the arrest on 8. Date of arrest shown as 8/7, but on the same day he was caught, my lord, by the my lord, local public from the spot, and thereafter, my lord.
The same day. He is from 7/7. Yes.
Yes.
Short may be given lordship.
On 12/8, my lord.
Sure.
Very pleasure, Lordship. My Lord, 483 BNS's bail application, my Lord. Offense under section 365, 392 of IPC, my Lord.
Sheeted case, my lord.
My Lord, this is a search-sheeted case, my Lord. FIR at page 14, my Lord. The allegation is that the accused persons has hijacked one magic, my Lord, magic vehicle with 22 quintal of betel nut, my Lord. And on the very next day, my Lord, all the accused persons were arrested, and all the betel nuts which are robbed are recovered, my Lord. Kindly see seizure list at page 36, my Lord. All the betel nut were recovered, my Lord, and the accused persons are behind the bar for 127 days as on today, my Lord. My Lord, we appeared before this honorable court. Kindly see at page 42, my Lord. We appeared before this honorable court as the charge sheet has been submitted. So this honorable court directed to appear before the learned trial court, my Lord. Accordingly, we appeared before the learned trial court, my Lord. Kindly see at page 44. We appeared before the additional CGM Borpata, my Lord, and our bail petition was rejected. giving the ground, my lord, at page 47. The ground was that page 47, para 19 of the order, my lord. Today, though bail petitions are filed for the above named accused persons, but petitioners have failed to show any sense in circumstances for allowing them to go on bail. This is the ground, my lord. Our bail petition was rejected. Hereafter, we also appeared before the learned session judge, my lord. That is at page 49. And the learned session judge also rejected our bail prayer, giving the ground that, my lord, page 51, para 12 of the order. In the bail petition, it is stated that the accused persons are very poor and they are only earning members of the family, that the accused will cooperate the trial. The grounds in the bail petition are not sufficient to allow them on bail. Therefore, the bail prayer is rejected. My lord, as the charge sheet has been submitted and we are behind the bar, my lord, for 127 days, my lord. So there is no any chance of hampering or tampering in the investigation, my lord. We are ready to cooperate the trial. So, my lord, we may be allowed to go on bail, imposing any condition, my lord.
Yes, what about this?
This case, scan copy of welfare and CD manual. For that. Other
You want to see what progress?
uh,
As per you, what is the stage of the case at present?
My lord.
At present, what is the stage of the case?
My lord, the stage of the case is it is in the CGM court and the case ought to be committed to the session court, my lord. Because the charge sheet
Not
has
yet
been
submitted.
my lord, ought to be committed because the charge sheet has been submitted under section 412 of IPC, my lord. The 412 is triable by the Court of Sessions, my lord. And my lord, in the Sessions Court judgment, my lord, it is given the 3 months time. Within 3 months, the case have to committed to the session judge. So this will take more time, my lord. And we are behind the bar for 127 days, my lord. So what will serve, my lord, after taking being remain in the jail custody? We are ready to cooperate with the investigation. All the stolen articles have been recovered, my lord.
otherwise, considering the nature of the case and length of detention, I will leave it to your lordship.
Hard Mr.
Take care, sir.
Hard Mr. A.K. Azhar, the learned counsel for the petition. And also hard Mr. B. Water for the learned petition PP, on behalf of state. And applicant, principal, punishment express. Submitted by Mr. Azhar, counsel for the petition. That the accused petitions are innocent and false within this case. However, all the alleged the Bethlehem which were alleged to have been theft by hijacking the truck are already seized by police during the investigation and during the investigation. Both the accused petitions are behind the bar
16
since last
No,
127
heavy.
days,
So,
and hence, considering their length of detention, they may be enlarged on bail. Mr. Fuster. Mr. Azhar further submitted that after filing of the charge sheet, the accused petitioner approached before this court wherein was directed to appear before the London trial court below. Accordingly, the petitioners appeared before the Granite Court of Additional CGM as well as the session judge, but their bail petition was rejected by the Granite trial court below. And hence the present petition had to be filed with a prayer for bail. Both the petitioners are the permanent resident of the and they will appear before the court repeatedly without bail as on date to be as and when it is fixed. Next para, Mr. Porter submitted in this regard that their earlier bail petitions were rejected by the London trial court, and considering the nature of the offence, he insisted to call for the case diary. a case scan copy of the case. Mr. Azad submitted in this report that as the case is as section 412 is also added, cases the cases triable by the court of session, but the same has not yet committed before the court of session, and hence it will take more time to complete with the trial for commencing the trial of this case. Next, considering the entire submission made by counsel for both sides, other aspects of the case, I find it proper to answer. So it is basically the case of Bongaigaon or where?
This is the case of Borpeta, my lord.
Borpeta.
My lord, Sorbuk PS, my lord. Borpeta district, my lord.
Case is still at the committal stage, not yet committed
Not yet committed.
to the satisfaction of learned state Borpeta. 30,000 with 2 COT per 2 COT. Okay,
Well, highly obliged, man. May I please, your lordship?
yes.
My lord, shown arrest here, the present petitioner. Earlier, my lord, 2 cases he was arrested. One case, my lord, he was arrested on 19/5, and on that case, he was released on bail 28/6/24. That was Nagaon PS 95. Again, my lord, the Polashbury PS case 85 was arrested on 5/6/24. He was released on 16/7. And again, my lord, the present case, my lord, shown arrested on 26/2024. If we count from the present shown arrest, my lord, there's 42 days. And present case is that, my lord, some unknown miscreant, my lord, at night hijacked a truck, my lord. The truck was loaded 900 carton of McDowell ram, that is, my lord, wine, my lord. And the driver was, my lord, held down from the vehicle. And on suspect, my lord, I think in this case, my lord, though the police, my lord, apply for application before the magistrate, my lord, to arrest him in connection with this case, my lord. Only a suspect, man. Because his long days, he was in jail, my lord. Police suspect that earlier case also was in same nation, my lord. So the suspect is there, he may be involved here. In fact, my lord, he is not involved, my lord. So 42 days, my lord.
FIR of this case was lost on when?
My lord, present FIR was lost on 27/4, my lord. 27/4.
Yes, what?
My lord, it seems that my lord, he is a habitual offender, and your lordship, vernacular, my lord, চালকজনক চকু মুখ হাত আৰু ভৰি বান্ধি ৰাস্তাৰ কাষত থকা পথাৰত পেলাই গাড়ীখন লৈ যায়. So not only my lord, doing
The
this kind,
case
but
is very
also-
bad, my lord. Yes.
Yes,
I
but the
admit,
case
my lord,
is
but
very
in
bad,
fact,
that
he
my
is not present in this case. Because generally we see, when a person arrests, my lord, and same national case is not found anywhere, they take the
Yes, that practice is there, I know.
under the custody. So
We
42
have-
days, my lord, today.
That practice is obviously there, I won't disagree.
Vehicle also recover and
But
item also recover.
the case there.
Yes.
You know the progress of investigation vis-a-vis the other aspect.
On
Yes, what about
16/8, my lord.
16.
16/8, so long, my lord. I think
No other short
42 days is behind the bar, my lord. And shown arrest, I think.
13/8, my lord.
38.
Obliged, my lord.
Here, CD may be called for.
Hmm.
It is for Bosishta. Next day,
It is from Bosishta.
my lord, Bosishta, my lord.
Yes,
We
what?
fix on 3, my lord. 3 ago.
3 Saturday, my lord.
Okay. 2. Bosishta, 2.
On my lord, 6 of 6,
My lord.
May I please, Your Lordship? This is second bail application, my lord. Please, up to that case, I made a call for.
My lord,
Earlier was rejected.
is rejected.
Rejected by Your Lordship.
My lord, I don't find any new ground, my lord. Apart,
Lordship,
there's no
regular
new
bail
ground.
application, my lord.
My lord, no, my lord.
Custody
This
is the-
Chandra Sarkar and my lord Raja's case, my lord. Without any new ground, my lord, they have to come in new. There has to be change in circumstances, my lord.
This is regular bail application, my lord. In fact, Your Lordship ordered, my lord, at this stage, bail application was rejected earlier. That was also mentioned. He is behind by what type of circumstances will be changed, my lord.
No, my lord. This is my lord. This is my lord. May I pass on the judgment?
Let it be afterwards we'll hear it. Let us call for the
Up to
case
that
diary
case,
only
right.
to see the progress of the investigation.
Lord.
Much.
Yes.
Lord.
Otherwise, there is no change of circumstances. Maybe as you have
Yes,
submitted.
yes.
And today's 38 days conviction is extended to 3 years. That's why my lord thought that maybe given. Punishment is extended to 3 years. 2 days, 38 days.
Whatever.
But,
Further than we can counsel for the petitioner and also her Mr.
D. Gogo, my lord.
D.
As
Then
counsel
we
excise, my
counsel
lord.
for the-
Excise, my lord.
Oh, sorry,
Excise.
excise. It is submitted by Mr. By MS Bora that this is a subsequent bail application after rejection of this bail by the order dated 15/7/2024 by court. It bail application number 1981 of 2024. Mr. Gogo submitted in this regard that there is no new or urgent ground in the present bail application and it cannot be entertained. However, considering the submission made by the learned counsel for the petitioner, I find that I find it proper to call for the updated case date to see the progress of the investigation. List the matter accordingly. When it can be listed then?
Next Tuesday.
Next Tuesday. 6/8. We are listing it on 6/8.
My lord.
Okay.
6.
Lord.
How long?
Oblate.
Right, please, Your Lordship. This
Yes.
petition is preferred against the judgment and order dated 5/6/2024, Lordship.
5/6.
5/6/2024.
Where you have annexed this one?
Annexure 1, Lordship.
Page.
Case 14. The operative part is at page, Lordship,
So it takes 9.
NA. I think the conviction was upheld, Lordship.
Mm.
And the appeal was dismissed.
Appeal was dismissed. Compensation amount was?
Compensation amount was 7 lakhs, Lordship. It was kept same, Lordship, 7 lakhs. The judgment of the CJM Sipsagar is at, Lordship, Annexure 4, page 30, Lordship. The operative part is at page 36, Lordship. 36, Lordship. He is sentenced to undergo simple imprisonment of 2 months and an amount of 7 lakhs, Lordship,
Yes.
to the victim bank. The compensation shall be recoverable in default again 30 days. Lordship.
This was passed by CGM.
Yes,
CGM Sipsagar earlier.
Sipsagar earlier.
So we are issuing notice and we are calling for the case record also.
Sentence may be suspended.
Have you filed any separate application or prayer is made here only?
Lordship, prayer is made here, Lord. Lordship, page 11, last part, Lordship. During pendency of the case, father he pleased to stay the operation of the impugned judgment and order.
It is a formal party, I think.
State is a common part.
Your respondent number 2 is the State Bank of India.
State Bank of India. They have filed the case. They were the complainant.
Oh, achha.
The manager has filed it. That is without authority. Lord, if the evidence come, it will be clear, Lord. I am narrating this.
So what is your main ground? Because we are going to suspend the sentence also.
Lordship, without authority, the bank manager has filed this case.
Without authority.
Without authority. And second is that earlier a case was filed. Lordship, that was withdrawn. Because what they are saying to be paid is paid, Lordship. Now, without authority, this case has been filed by the manager from the higher authorities of the bank. He has kept the check and filed it and without the authority of the higher authority of the SBI.
Okay. But Mr.
Yes.
Hard Mr. for the petition and also hard Mr. P. Water denying the additional PP applicant behalf of state respondent. And this is an application of the constituency in connection with so to notice to the respondent no formal notice by the constituency and also call for the scan copy of the LCR. Submitted by Mr. Sharma that there are such ground for succeeding the present petition and the complaint has been lodged by the manager of the bank without having any authority from the higher without authorized from by the higher authority, and more so they have filed the petition after withdrawal of the earlier complaint. Apart from that, there are some other grounds also for the succeeding in the present revision petition. Court it is prayed that during the pendency of this case, the sentence imposed on the present petitioner by the learned CGF and the learned additional session judge so and so in connection with so and so may be suspended of the state till disposal of this so and so. So he is still under previous bail or any
Previous bail.
further the petitioner further he prays to allow the present petitioner to remain on previous bail till the disposal of this so and so. Next further, considering the submission made by the Learned Counsel, Mr. Sharma, and the other aspects of the judgment and order dated 25/5/2017, passed in CR case number 27 of 2013 under section 138 of the NI, passed by Learned CGM Sibsagar, and the order, impugn judgment and order dated 5/6/2024, passed by Learned Additional Section Judge Sibsagar in criminal appeal number 31 of bracket of 2 of 2017. The state shall suspended till the disposal of the present petition, and the petitioner is also allowed to make on previous bail till the disposal of the present petition. List accordingly. Okay. To take steps for the response number 2.
Obliged.
May I please your lordship,
Yes.
this petition for revision of the complaint case filed by the informant, who is my friend. We had an agreement to start a gas agency. So each of us has contributed 1,90,000 each. As I had no money, I took loan from the person, petition informant, and I have returned the amount. Now, since I asked for this documentation, she has not returned. Then she filed a CR case under 420. Well, assuming that money has not been returned, can 420 lie? Then all banker will go to the criminal court, file a CR case or criminal case. The money has not been returned. That's why before this is the learned magistrate, when he took the cognizance, there must be satisfaction. There is a series of judgments Supreme Court. There must be a satisfaction of the magistrate. Yes, I have satisfied that there is a material on it. And one witness was examined. She said that I have written the document, but and I know that the money was paid, but I do not know whether it's returned or not. That also happened. So my prayer is that further proceedings may not go. It is a wrong signal in the society.
Where is the order? You have annexed?
My lord, I take your lordship. My lord, page 25. If there is a transaction and money has not been paid, there is a document, she can go for a civil court for recovery the amount. Money should be filed. And kindly peruse the para 6, my lord. Para 7, my lord, kindly, para 7. The petitioner begs to state that perusal of the complaint petition of the statement under section 200 CRPC witnesses, she was shocked and surprised as the statement made therein is absolutely false and fabricated. The actual fact is that both the petitioner and the complaint voluntarily intended to a partnership business of LPG and gas agency with equal contribution. For that, the complainant paid the contribution of 1,90,000 in cash and the petitioner on 23/5/18. Subsequently, a dispute arose between them in a partnership. Petitioner immediately on 35/18 returned the back 60,000 in cash, and the complainant, and she has invested in the business, told that she would return the balance amount within a short time. The complainant, who is also doing business and money lending, started demanding the huge interest and forced the petitioner to execute a kacha unregistered agreement on 1/3/20 by force. Accordingly, the petitioner paid 1,50,000 in the cash to the complainant on 8/3/20, thereby already paid the principal amount of 1,90,000 plus 20,000 as interest. With all motive, this ill motive to extract more money from the petitioner, the complaint has lodged this instant false case fabricated complaint. As such, the petitioner has not committed any offence under 420 or 506 IPC. So, I have not done anything. Offence has been committed under criminal law.
My lord, though in the complaint case there is stated that when he asked for money, because dire consequence that is there. But in the initial deposition case 21, only নয় পইচা খুজিলে নিদিয়ে মই বেয়া ভাষাত গালি পাৰিছে।
But 5 years, he should go to the direct case কৰিছে.
Otherwise,
it is a CR case, though we have made the state as a party.
It is not there.
The learned counsel for the petitioner also had for Asha, the learned additional BP, appear on the state respondent number 1. The Senate petition, section so and so, connection with so and so, issue notice to register. No formal notice is required to be served on so and so. Mr. Biswas, the counsel for the petitioner, for the submitted that the false and concocted case has been launched against the petitioner only to harass her it is the fact that uh, would inform the petitioner were started a business together, and they contributed an amount of rupees 1,90,000 in 90,000 each. But thereafter some dispute arose between them. The petitioner, the complainant asked her to return the money, and they had already returned the principal amount along with 20% interest. But thereafter, she started harassing the present petitioner, and with false and concocted allegation, the complaint has been lodged. Accordingly, it is submitted. It is paid by Mr. Viswas that till the disposal of the present petition, the part of proceeding is case number so and so. So, CR case number 12 we state till this case. Expert consider enters the petition made by the learned for the petitioner, and it's available in the case report. The part of in case number the state till next listing. List accordingly after 3 weeks. Okay, it will be stayed after till next date of the fee.
No, further proceedings may kindly be stayed. Further proceedings.
Further proceeding is stayed till next date of listing.
Obliged.
The complaint case is 482 application has been filed for quashing of the complaint lordship, and subsequent order dated 10/6/2024 for taking cognizance under section 500 IPC lordship. In this case, nowhere in the complaint petition lordship they have made any averment under what about the contents of the statement by which their reputation was maligned by the complainants. Page 36 is the complaint petition annexure 1 lordship. Can you turn to page 42? Page 42. May I read?
Yes.
That on 11/3/24 to the utter shock of the complainants, the accused person held a press conference in which false and concocted news was published in the Assamese news channel such as DY365, Protein Times, and NKTV News. The accused person deliberately misled the media at large to publish false and defamatory allegations against the complaints. Subsequently, on 12/4/3/24, Bharat Print Media Assamese Daily Newspaper Proceeding, the accused published an article page number 7, continued page 14. In written format, the false and concocted allegations against the complainants in order to intimidate them and to malign their repute by the malafide usage of the print and digital media. There is nothing in the complaint petition regarding which statement has been made to malign that. Second,
there I think in page numbers from 7 to 14.
Yes, Lordship. They have made. Then subsequently, that was the accused person in the press related and media conference have stated that a piece of property measuring 49 because of odd belonging to the Holadar Bhuya, a freedom fighter situated in the Marigaon district, had been fraudulently sold by the complainants by using falsified documents of the of the death of the children of Srimati Aruna Bhuya, and as such have illegally obtained mutations and other sale permission from the appropriate authorities in order to alienate the land. The accused persons have also alleged that subsequently the entirety of the land in questions has been sold for an about absurd amount of money as per the release of the telecasted news clips published in NKTV channel and primetime news channel as well as the news articles published in the SMS newspaper Procedural Lordship. They mention about the telecast that we have not appeared before any TV channel in live Lordship, and any publication in the news channel by the print or digital media, it is the responsibility of the editor of the news owner or the editor of the newspaper and news channel. But that news channels have not been made party in the case. Lordship. And subsequently, in this case, it is a true fact that the property has been sold, and there is some cases pending before the Deputy Commissioner and Circle Officer for cancellation of the mutation of the order, and before the Honorable CM Assam Lordship. An inquiry was made by using a false documents from the Ward Commissioner. The complainant has have mutated their name in place of the deceased brother of the petitioner number 1 and 2, Lordship. All the are true facts, and in the true facts, it is come under the exceptions of the under section 499 IPC Lordship. In any case, without making the editors in the print digital or print media, the case cannot, it is not maintainable, Lordship. And it is a true fact. I have annexed all the documents regarding this mutation case and other case pending before the.
Have the Mr. already took cognizance in this case?
Yes, Lordship.
Where is the order?
That is the order. Annexure 3, Lordship. Page 80. And statement made under section 200 and 202 of the CRPC also in parroting statement written by the magistrate, learned magistrate, probably learned magistrate himself, Lordship. Can you go through page 80, annexure 2, annexure 3, Lordship. 10/5/2024, Lordship. Annexure 2, the deposition of the complainants as well as the other under 202 of the CRPC, Lordship. It is a parroting statement before the magistrate. Same statement. How can it is possible, Lordship? Possible, Lordship. Each and every statement are same.
Yes.
Annexure 9, Lordship. It is the page 117. It is the documents wherein the name of the complainant is only shown as a party, the surviving legal heir of the deceased person. But there are some other surviving legal heirs of the deceased, Lordship. But they have not been made party in anywhere in at the time of the mutation of the case, Lordship. Annexure 8, Lordship, page 116. Can you see the report of the government, certificate of the government authority, district commissioner Nagaon, Lordship. The relationship between Haladar Bhuyai and other surviving legal heirs.
Malat, it's not like that the news channels reporter went and they collected the news. It's a press meet. From the press meet, what they have stated and it is published in the news. So, Malat, regarding the press meet, Malat, page 56, Malat, that complaint petitions.
Regarding press meet, it is the duty of the editor, lordship, to he has the responsibility.
Page 56, part of the complaint petition, para Roman 9, that no point of time the accused one and two are the proprietor of the state property, thus eliminating the requirement of the complaints to force that any document in this regard, accused number 1 in this regard, that the complaint bona fide believed to stole the rightful owner of the personal have legally obtained the requisite permission, but I have to show that the value of the land is 1 crore 50 lakh, that is. So there is something maybe, Malat, we don't know at this point of time, Malat. And it's not like that news channel publish the news. News channels are not made party, but because of the press meet,
but it cannot be published, lordship. If press meet, it is the duty of the, this is the judgment of the Honorable Supreme Court. As per press and books of publication of books and accounts act 1867, lordship, this Honorable Court also, Apex Court also decided that editor must be implicated as a party in the case, not other owner or other. It is a long case, but I have given last page of that. Last page.
Notice me.
Moreover, the ladies, they are the aunt of the complainant, is aged about 91 years and 75 years, respectively, lordship. They have been made, it is a malicious prosecution, lordship. I go to the Julius. I go to Julius. Repeat it.
It order principle, it is can be in order. Issue notice to the respondent.
There is Jugesh Mohan, Dr. Jugesh Mohan.
Normally, issue number, no notice issue.
They to BJP president to
paragraph 2 process. No formal copy is required to be furnished. I get the state response number 1 as the additional has already also called for the scan copy of the it is submitted by MSDF that the present accused petitioners are innocent and false complaint has been lodged against the present accused petitioners. Against petitioners, more so from the complaint, it is seen that the news channel and the print media, etc., are not paid party in this in the case, because it has been alleged that a false news was published in the news channel as well as in the print media. Further, that it is a true fact that the respondents were entangled and respondents were falsely mutated their name. They mutated their names and tried to grab the land. And but there is no mention in the complaint itself as to how they are malign in the society. Accordingly, MS State submitted that the further the Further, he submitted that without applying his mind to cognizance of the offer against the petitioners, and accordingly she submitted that further proceeding may be stayed in respect of the present petitioners if the disposal of the present petition. Next, Maharashtra, the learned PV submitted in this regard that not a case where the print media had published news channel or the print media had published the news, but the petitioners uh, uh, attended a press meet wherein they declared about the malpractices or allegation of for the allegations of grabbing of land. Present false certificate here. False certificate. Miss FSD submitted in this regard, even if it is a press meet, as the news channel has already been published, as the news item has already been published through the print media, the media persons ought to have been made party in the complaint petition. In this regard, she also relied on a decision of the FX Court reported in 2013, 3 SCC page 697. 697.
It is a different case, Lordship, but regarding the responsibility of editor, it is stated in this case.
Have been made by I find it proper to state the further proceeding of till list accordingly after 3 weeks. Till next date of listing, your the proceeding is stayed. Issue notice to the respondent number 2, 3, and 4 to register daily and as usual process, and it will be listed after 3 weeks.
After obligation.
May it please, Your Lordship. This is an application filed by the state, my lord, for regarding cancellation of bail, my lord. At this stage, my lord, notice may go to the respondent, my lord, and returnable after 4
What was the case, in fact?
My lord, here is the case, my lord, the State Council of Education, Research and Training, my lord, where defalcation of money, my lord, 105 crores 76 lakh 26,000 rupees, my lord, defalcated, my lord. Without execution of any work, my lord, this money has been defalcated. And, my lord, they have granted well, because of which, my lord, we have stated silent cancellation of bail.
Bail order you have annexed?
Yes, my lord. That is, my lord, Annexure C. (32), my lord.
Is not
Is start from 32 Annexure C, my lord.
heard Mr. Amphicon, the learned PP, for the petition. This is the application for application under 439(2) of CRPC, dated 439 CRPC, for cancellation of order dated 16/9/2022, passed by learned special judge Assam in connection with Vigilance PS case number 03 of 2023 under section 120, 406, 409, 201, 468, 471 IPC, read which section 7A/12 of the 13(1) small a/13 of the AC Act, read which section 8 of the Assam Fiscal Responsibility and Budget Management Act 2005. You can see from here also. Again, read with section 41 of the Assam Public Procurement Act of 2017. How many responses?
Only one. Sole respondent.
And as usual process. Here, I think it's no need to call for any. Order is already here.
My lord, yeah.
So we are fixing it on. Let's see, after 2 weeks we'll do.
My lord, 4 weeks also, my lord.
After 4 weeks.
My lord. Much obliged.
Kindly adjourn for the day, my lord. I have to place some judgment. My lord. I have to place some judgment on this matter, my lord. So that
The request made by the request made by the Toxicological petition. Adjourn. List accordingly when 2 weeks. After 1.
one more matter is that item number 39. CD is not received, my lord.
39.
39.
Yes, CD not received.
Interim is there.
Yes, my lord, this is an interim from Stirang, on 21st of August.
21 is CDB call for entry be extended.
Interim is there.
Yes, we are extending the entry.
Okay.
1 3.
May I appeal, Lordship?
Yes.
FIR is page 10, my lord. In this case, my lord, 2 persons, namely Saiful and Khushidul, they are caught red-handed and seized, my lord, 2 fake gold boat, my lord. Whereas, my lord, in this case, my lord, petitioner is not named in the FIR. But at the instance of one accused, my lord, Saiful Islam, police visited the petitioner's house and asked the family members to appear before the police station. That's why my apprehension of being arrested.
Total weight of the fake gold is 3 kg 32 grams.
And
he is not there, but why he is apprehending?
Yes,
Yes, this case that is.
This kind of things are going on, especially
Yes.
in Dr. North.
Lakhimpur now is a
And now beside this area. It's very
But in
prevalent.
this
I don't
case,
know
my
why it is prevalent in that areas, but it's very prevalent. Especially Lakhimpur North.
Yes, yes,
now
not.
this
At that area, my lord, is frequently is happening.
So here it's not a case of any interim. Just we are calling for the case diary. Definitely will try to give you a, I guess, Parashar can.
View Korea.
In this, we don't have, but still 12, 13 can.
19 my lord.
Interim nahi ke bana.
13 my lord.
Let us see his involvement. If it is not at all, then definitely it's
Obliged.
13 CD 14.
May I please?
Yes.
The petitioner before a lordship is a government servant, the constable Assam Police. Page 10 is the identical annex. Is a constable of Assam Police, 6 APPN, and presently posted at Kasar and permanent resident Dhubri. And FIR before a lordship is page 2. I have page annex 2, page 11. Yellow. In this case, your lordship, the concealing her marital status, the informant made relation with the petitioner over his book.
And after 3 years of relation, when the petitioner has come to know about that she's a meritorious, tried to avoid them, then she lost instant affair. And prior to this affair, the petitioner's father also lost and complaint case. Till page 11 is the affair you can represent.
So you are for the page 11.
Page 11
Ah.
against me. Your Lordship.
Yes.
And prior to 1 month, 36 days before, we have lost complaint case. Here, father of the petitioner is page 18. Page 11, Your Lordship.
Page 18.
Page 11, Your Lordship. 11 is the affair against the petitioner, instant case.
And page 18 is the
CR case filed by the petitioner's father against the informant. It is prior to 2 months back, 36 days
prior to lodging of the said FIR.
prior. Page 11 is the affair, current is instant affair. Your Lordship, informant, Dipti Bora, wife of Sri Rajiv Kaur, kindly come. Wife. And date of affair 18/3/2020. I am reading, Your Lordship. With due respect, I have the honor to inform that the above mentioned accused Sri Nipen Bora is a constable of 6th amphibian who is known to me for last 3 years through social media, Facebook, and he came to our house on several occasions. On 9/12/2023 at about 7 p.m. he came to our house. 9/12/2023. House and took me to Dimapur for Nagaland for shopping. He came to our house for without taking breakfast. Therefore, at 10:50 a.m. he took me to room number 20 Hotel Kingfisher, and after taking some foods, he forcibly made rape inside the room. He kept a naked picture through his mobile phone and kept me whole night inside the hotel. And on next day, on 10/12, he came to our house to drop me. He said to me that I have to inform at my house that due to illness, his mother, I have to accompany her at Dimapur in the night, and said Nipen also said that if I disclose the incident happened to me so and so, I'll viral the naked photo of his mobile phone. In this way, he communicated with me, and I have continued to relation due to care.
10, page number 33, my lord. Fexers, there is a fexers, my lord. Let's call for the shielding. Give me a protection, my lord. Call for the border shielding.
Both the case, this is seeking bail in Sipazar 24/24. Other
25.
First case is 25/24.
My lord.
In both the case, in the present case, 326, 307.
My lord. Oh.
In that case, 325, 326. Present case, 3 person injured. We don't know in the other case what is there. So only case there. Both the case there.
Obviously,
Maybe land dispute, maybe.
Civil dispute or the land dispute
My
between
lord.
the parties.
My lord.
In that regard, one tax dispute was also there that has been decreed in your favor. These are already there.
My lord.
The question is on the pretext of that order or the decree, you cannot assault a person or the family.
My lord, they give me an opportunity to give me an opportunity to record my statements, my lord. Give me an opportunity, my lord.
Call for the case diary. It's not a case.
Both the case there.
Along both the case record, call for Kuribo, Sibazhar PS case number 24 of them, and Sibazhar PS number 25 of 24, along with the injury report.
12, my lord.
On 12.
12.
25 also, my lord.
Both the case
my lord.
12 feet.
12 feet.
Leave your place.
Supplementary also there, no.
May it please your lordship. My lord, this is a charge-sheeted case, my lord. So I have gone through the record, my lord. 3 witnesses only examined, my lord. And this petitioner is behind the bar, my lord. 1 year, 9 months, 19 days, as on 50, my lord. Earlier, your lordship was pleased to reject, my lord. I have also annexed that reject order. page 54, my lord.
As per your instruction, till now, how many witnesses?
3 witnesses, my lord.
Three
This
witnesses are being examined.
examined. Total 11 witnesses, my lord. So, my
11
lord,
number.
yes. That's it, that's it. My lord, I have annexed
And
the chip, my lord.
what is your term of I mean, since when you are in custody?
10-12, my lord. 22. 10, my lord, 10-12-2022. I have calculated, my lord, 658 days. Yes. This amount, my lord, 1 year, 9 months, 19 days. So, my lord, long.
Yes, Shama.
Here, Lordship has earlier rejected it on 6/3/24, Lordship, 6th of March 2024. Thereafter, Lordship, from the order sheet I have found, Lordship, on Lordship 17/6/23, PWs Noyan Das and Kamrul Islam were present but could not be examined, Lordship. That is the order, Lordship.
On when?
17/6/2023.
No, thereafter examined.
Two PWs present could not be examined.
Could not be examined. Thereafter, Lordship, on 15/7/23, 2 PWs were examined, Lordship. 15/7/23. Thereafter, Lordship, 11/8/23, 1 PW was examined, PW number 3. 11/8/23, 1 was examined. Now, Lordship, after 11/8/23, on 31/8/23, the case was again fixed, Lordship. Here, Lordship, the order I have gone through, it is stated, Lordship, advocate for the accused did not turn up for pending bail application. So, their counsel were not present, Lordship. After that, Lordship, once again, on 21/12/23, on 21/12/23, Lordship, 1 PW, that is Pranab Mili, is present, but defense counsel has sought adjournment on 21/12/23. Then again, Lordship, on 6/6/24, PW is present but could not be examined.
Is there any reason why could not?
No, Lordship, no reason has been given.
But it is an admitted fact that till that 3 witnesses are being examined.
Yes, yes.
Out of
11
numbers of
out of 11, Lordship, and the
11
next date is was fixed on 23/7/24. On that day, Lordship, I do not know, Lordship, whether any witnesses turned up or not, Lordship. It is not up to date. On 23/7/24.
As per you, on 23/7/23?
My lord, no witness was examined as per my
No, on 23/7/2024, last date.
last date.
Is there any examination?
No. As per instruction, my lord, no witness was examined, my lord. And my lord, before that, we have also submitted the bail application that was rejected, my lord. Page 60, my lord.
60.
60.
Now, Lordship, my submission will be, Lordship, on 2 or 3 occasions, Lordship, PWs were present but could not be examined, and on some occasion, Lordship, they also have short time, Lordship. So, Lordship, delay on account of the prosecution alone cannot be said, Lordship. There are some other results, Lordship. So, Lordship, now the case is progressing fairly, Lordship, and within a short period, it would be over, Lordship. That is my submission, Lordship. And
Page 60, my lord.
And regarding merits, Lordship, has already reflected in the order dated 60/24, Lordship. There are ample materials, Lordship. That has already been reflected by your Lordship. That is my submission, Lordship. Lordship can grant some time, a time frame can be given to complete the trial.
That will do,
That
my lord.
also will do.
If your lordship frame some time, my lord, within that period, they may conclude the trial. Otherwise, also, my lord, it will take much time, my lord,
Also-
because
also-
11 witness, my lord. Only 3.
If
Questions.
lordship direct some time frame, lordship may also reflect that they will not seek time.
We will
That is
not seek,
also-
my
that is
only
also
one
of
time,
the reason.
as by my instruction, my lord, only one occasion we have taken time. That is another appeal. Yes.
Okay, I'll pass you.
Obliged.
So lordship, CD has not been received. Lordship.
My lord, last occasion while CD was not received, my lord, landed PP, my lord, argued that one chance may be given, my lord. My case was, my lord, finally see the FIR, my lord. The girl herself, my lord, from Bayhata, my lord, went to my room. And my lord, the allegation date on the plea of my lord is on the plea of marriage. He established physical relation twice, my lord. And my lord, I also, my lord, submitted one Honorable Supreme Court judgment there. I have come with the judgment, my lord.
Your petitioner is behind the bar since when? Since when your petitioner is behind the bar?
62 days.
62
31st
days.
May. 31st of May. My lord, there is still chance of marriage, my lord. I took talk to the father of the accused. And my lord, the girl herself went twice, my lord, to the Nalbari jail to visit the accused. Apart from that, my lord, her allegation is only see, my lord, later part. On 27/5, he committed rape. Then again she came on 28/5. Herself she attended পদক্রিয়ায় যেহেতু পদক্রিয়ায় মুখ বিবাহ করবার প্রতিশ্রুতি দিয়ে so my lord exactly the Supreme Court judgment on the same line. In that case, my lord,
Yes, Romani.
Lordship, we can try and produce the case that next week.
well, twice, my lord, they got the chance.
Monday, lord.
He prayer from my lord Bayhata. My lord, at 62 days, my lord, and nature of allegation, my lord,
Twice since not twice.
yes,
On
right.
77 case was there. It was called for the case there. Next day is today only.
Yes.
This is the first day.
Yes,
Last occasion also,
17/7 is the date when the first CD was called for, and today is the first day.
my lord, last occasion also for city, today is also for city.
Last occasion is also for CD?
Yes,
No,
yes.
no, it's not there.
Yes, my lord,
First date
Yes.
when a CD was called for, in fact. On 17/7, it was the first day when the case was.
On 17/7, it was more, my lord. On 26/7, it was for city. 26/7, and now, my lord, 21st, 31st. On 26/7, my lord.
Monday, Lordship.
Yes, Monday can be.
Monday. Lord.
Correct, Monday. Issue reminder Monday.
My lord, observation may be given, my lord, because twice they failed, my lord. And my lord, 62 days, my lord. So if he failed to produce next occasion, my lord, then my lord, without sitting my case.
Yes, 25.
25 also Lordship, CD not received.
25 also CD
Oh,
not received.
Ma'am, listen, this is the third consecutive for the CD on 17th, 25th, and 31st.
Same
It was
for
for the, yeah, for the CD. This is the third consecutive one. My lord, two words are very important. One is bonso, and another is specifically mentioned here in the FIR. FIR page number 1 to 12. Yeah, allegations regarding the extortion. Here, the petitioners are the student union members. That is the Bodo National Student Union. May I read the FIR, my lord?
Sharma, days have gone. What is your pay?
I am already 44 days behind the bar, and there is a affidavit, my lord, from the shopkeepers, specifically in the mention in the FIR from the that is from the below, in the first paragraph from the third line, that from the shop's BB Paradise Point. That means this is a particular shop where they have alleged that I have demanded and collected the money. My lord, there is a affidavit where the owner of the shop is saying that they have not collected any money, nor demanded any money from the shops. So affidavit has been annexed. Case number 23, my lord. It's only a political motivated because I am a Bonso student union, and there is another student union called All Bodo Student Union. And the Bodo Union student is being supported by UPPL government, and the Bonso is being supported by the BPF. And that is the class and nothing else. In reality, nothing is there. I'm wrongly implicated because there's a Bonso student certificate is also there in the page number 14.
Where you have an extra affidavit?
Additional affidavit, my lord. Page number 23.
When you have filed your additional affidavit?
On 26, my lord.
26?
Yes, of this month. Because on 25 there was a hearing.
It's not showing, it's not tagged here.
No, my lord, I have given. I have submitted.
No, we see. Sharma, have you received the additional one?
Yeah, Lordship. Yes, Lordship.
It may be our thing. We can call for this.
No.
It will be for 10-15 days, of course.
My lord.
Please. This is regular bail application, lordship.
It is not received, Lordship.
CDs are not received.
And lordship, as on today, 64 days in custody, lordship. But lordship, lordship, and as per the FIR, lordship, and some article has been, some money has been seized, but these are
Don't know,
the
but
fake currency, lordship.
call for case diary, so we have to wait.
These are the Xerox paper, lordship. Otherwise, demo, lordship, not fake currency, lordship.
Lordship, next week we will produce the case.
Next week, can it get shorted?
Lordship, 8, Lordship.
8.
8.
We're calling it on 8.
Lordship. Published.
Yes.
27 also, Lordship.
Lordship, in this case, lordship already granted bail on motion to the other co-accused, lordship. This is the lordship Gorchuk PS case, lordship, in the guest house, lordship, gambling act. All the out of 6, lordship, already 5 already been released on bail on motion, lordship. That is on page 18, lordship, FIR. He's a tea stall near the guest house, lordship. He went there to serve the tea, lordship. In that time, lordship, police has picked up other person, lordship, including this person also, lordship. Lordship is granted bail on motion, lordship, on the list. Considering the same footing, lordship, I'm the same forwarding accused, lordship.
They are playing cards, Lordship.
Only playing cards, yes.
And your petitioner is a tea staller.
Tea staller having near that guest house, lordship.
FIR name accused 6, number 6.
FIR name.
The FIR number accused 6.
Accused 6.
It is submitted. Submitted, but in case it is CD not received. Then the restrictions Mr. Forgery petition submitted in this regard. That the present petition is not involved with LSJ, and he has a tea stall near to the guest house, and he went to the guest house only to serve tea when he got arrested, that can be discussed. Submitted he has not committed any such offense as any effort but from public prosecutor submission again রাখিব since when he is in custody.
He from the same date, Lordship, on 13/7, Lordship. Same forwarding, Lordship.
Okay, it will be done.
Highly obliged. Oh, 20 में कहीं लेकिन after some time only. So 5 minutes. Obliged.
Wait, please, my lord. This second bail application, my lord. The allegation, my lord, is under section 307 and 326, my lord, of IPC, my lord. And my lord, as per my lord, your rejection order, my lord, kindly see page 15, my lord. Here, my lord, specifically stated that 326 is not attracted, my lord. Page 16, my lord, para 6, my lord. And case diary was called.
So what is the new?
Yes, my lord.
There also it is observed that 3026 may not be fair, but the
Yes, my
attack
lord.
on the vital
307, my lord. Yes, my lord. As per FIR, my lord, there is some intent.
What is your new ground or any?
Yes, my lord. For abstraction of 307, my lord, there is an intention to kill, and my lord, severe blows should be, my lord, there, my lord. As per my lord, one judgment, my lord, Shivamani of the Tribunal of Inspector, my lord. If there any severe, my lord, that if my lord, oral alteration is going on, then my lord, there is some attack and he, my lord, fled away, my lord. There is no intention to kill, my lord, the victim, my lord. And injury also simple, my lord. That was my lord. Here, my lord, Shivamani, my lord, para 10, my lord. Having considered the facts and circumstances of the case and submission of the learned counsel for the parties, this court is convicted that the impugned judgment of the High Court requires to be interfered with. Admittedly, there is no allegation of repeated or severe blows having been inflicted. Even the injuries of PW1 and PW2 have been found to be simple in nature, which is an additional point of the appellant's favorment. That is the point, my lord. That I have no intention to kill the. There is some alteration going on, and suddenly that was happened, my lord. There should be, my lord, repeated blow, my lord, should be, my lord, for attraction of 307. That is my submission. And injury also simple, my lord, in nature, my lord.
Yes, just any new ground.
My lord, injury report is given by the primary health center only. Now, eyewitnesses are there, my lord. He was injury. This is the medical. 3 stitches were given. Last portion of the injuries are there. Eyewitnesses are there to the open. মেডিকেল কলেজত লৈ গৈছে নেকি?
Case 7.
মেডিকেল কলেজত আছে নেকি?
And page 17, my lord, in my petition, my lord, there is a medical report, my lord, of Borpeta Medical College, my lord. It was impressed.
Medical report.
Yes.
Whose?
Patient, victim, my lord.
You have collected this one.
Yes, my lord, I got it.
Where from?
Borpeta Medical College, my lord.
So I did not find it in the. I did not find it in the case diary.
No significant of intracranial abnormality, impression, my lord. Mild scalp swelling in right peritoneal region.
The earlier petition was rejected. Definitely, there is no sharp cut injury or previous injury. It was not so.
He was hit by a hammer.
He hit the victim with a hammer.
Hammer, and in the vital part of the blood.
That is the observation. But this time, if you say that the progress of investigation, that is the only ground for consideration, otherwise there is no ground at all.
But there is no new ground otherwise.
No new ground, nothing is there, except maybe for the progress of investigation. That may be the only ground, otherwise no. No other.
Some progress has been made, blood. So witnesses are examined, a good number of witnesses are examined, blood.
That may be
I have no intention to kill my lord. That is alteration. I will appear, my lord, and I will give.
Then why you
No, intention is a state of mind, blood. It is difficult to say. He will say he has no intention.
cannot judge.
But from the injury inflicted, that indicates that he had intention.
There is a public meeting is going on, my lord. If there is in separate place, my lord, that was, my lord, in public meeting that was happened, my lord, as per FIR, my lord. So they are
age ki manta?
50 more. 35 years.
No, petitioner 21 বছর নাকি?
It is 21 years. He is only 21 years. No intention to kill, my lord. That is altercation going on, my lord. Then suddenly happened, and after that, my lord, he fled away, my lord. If there is an intention, my lord, he will repeatedly blow, my lord. That is the case, my lord. I will appear, my lord. But then in nature also, my lord, simply injury, my lord.
নতুন গ্রাউন্ড কি দিচ্ছে? নতুন গ্রাউন্ড এখন জাতীয় কারণ নতুন গ্রাউন্ড হবো।
Had Mr. M. Kalita, Tilani Council, and also had Mr. Vidas, Tilani petition.
His only new ground maybe because a young boy. That otherwise, I do not find any new ground.
Vidas, and PP application behalf of the respondent. That application and section so your paribaran so in connection with so it is submitted by Mr. Kalita that earlier his earlier bail application was rejected after perusal of the case and the petition has been filed by him only on the ground that there is sufficient progress of the investigation, and in the same time he submitted that the petitioner had no intention to kill the informant and the victim, and the incident had happened in a general meeting wherein some altercation was as well after some there might have some tussle between two groups, and apart from that, he has not committed offense as a clear. More so, as per the medical report, he sustained an injury on his minor injury, and if he would have any intention to kill the victim, he could have assaulted him repeatedly on his vital part, title part to attract Section 307 IPC. More so, he submitted that he being a boy of a tender age may be released, may be granted one more chance to cooperate with the IO in further investigation of this case. Next paragraph, Mr. Das submitted in this regard that there is no new or urgent ground in the present petition with its subsequent bail application. However, Mr. Das submitted that considering the progress of investigation and the injury sustained by the victim, vis-a-vis considering the equity of the one chance may be given to cooperate in the investigation of this case. To cooperate the IO in the investigation of this case. Next one. And only considering the progress of investigation and other aspects of the case, I find it efficacious to extend the privilege of pre-arrest bail to petitioner so that he can appear before the IO to cooperate in the investigation of this. Accordingly, it is provided from the pre-arrest bail 20,000 with one surety to the satisfaction of the arresting authority. This petitions that is both of them. Okay, will be granted bail.
Obligement.
One.
31. CD was called for, my lord, in this case, my lord. The petition has been filed under section 438 of the CRPC, my lord. The discriminatory allegation is absolutely in civil nature, my lord. Kindly see the FIR, my lord, which is page 13, my lord.
Page
13, my lord.
Second or third petition? Second or third? Third petition. You were rejected. This is third time, my lord.
The petitioner, my lord, he has purchased the land, my lord, from the informant, my lord, way back in 1998, my lord. After purchase, my lord, his name has been mutated. Thereafter, my lord, till date, my lord, he is paying
Your chief has already reviewed the case.
revenue tax, my lord.
Even
Civil
Milord,
nature, my lord, he will cooperate the investigation, my lord.
Zakir Hussain,
Yes,
the
yes,
main
yes.
accused. And I have gone through the case that in 2-3 occasions.
Yes. After purchase the land, my lord, his name has been recorded in the
Yes,
revenue
yes.
record, my lord.
The way of purchase.
Along with the informant, my lord.
Yes, obviously.
Purchase, my lord, made, my lord, in 1998, my
Yes,
lord.
yes, I know.
Yes.
So no way out.
If it is civil nature, my lord, he will cooperate with
No,
the
not
investigation,
civil
my lord.
nature. He has done things, you know.
Force sale deed.
Force sale deed.
Force
Everything
sale,
is
Milord.
forced. Everything is forced.
The circle officer failed to give the mutation case records. Not available in the CO.
No, my lord, kindly see the mutation.
Without anything, my lord,
kindly see
his
the
name has been
page number
mutated.
25, my lord.
Case of the Milord.
Case number 25, my lord. Mutation order, my lord. Dated, my lord. 2/7/2013, my lord.
But where this order was
my lord.
passed, that case record is not available in the CO office.
That is the
Not available. This is not available. Even this order is not available.
Yes.
How can he obtain this order, my lord?
Yes, yes. We don't know, but this is also forced.
Under the seal and signature of the circle officer.
That is the modus operandi.
Twice in 3 occasions that has been
And
rejected.
on,
You can better
in
for the higher
23 also, my lord,
authority,
in
is there
3
anything?
months he has
My lord,
paid,
yes, yes.
he has paid the revenue
You
tax,
may
my lord.
approach the higher authority for
Yes,
the
my lord.
Supreme Court order, Supreme Court.
How can it,
But
my lord?
3 times this has been rejected.
Case 33, my lord, the revenue receipt, my lord. From the
Revenue
seal and signature of the
anybody.
circle officer, my lord.
Okay, these are we have collected all.
Yes, my lord.
And 3 times this is rejected. There is no new and any other ground. So we are not in a stage to allow. Better to move on before the.
I have stated the new ground, my lord, in paragraph number 15, my
What
lord.
is the new ground? Yes.
15, my lord, page 8, my lord.
Yes. Yes, what is the new ground? Your duly purchased mutated system. That is not the new ground. isn't it?
He is a civil support.
So this is the ground that you're not collected your purchase. These are things are there.
Yes, my lord. Thereafter, my lord, he has obtained the Form 50 also, my lord. Last case, my lord, which is at page, my lord. Page, my lord.
That case then I can remember
40, my
name
lord.
also.
Page 40, my lord.
Okay, case. This is the only one.
The name of the petition, my lord.
50?
Form 50 has been allowed, my lord.
Yes, these all are allowed. All things are there. All records are with you.
Page 40, my lord.
Yes, that's what that is the case. You have every document. You have mutation. You have Form 50. You have
Yes, my lord.
everything. You have everything. That is the main issue.
He
So-
had all these documents.
Yes,
my
you have
lord, 10, my lord.
all these documents.
Then, my lord, the
You have
official
obtained all these
must
documents.
have
That
been
is the
my
main
lord,
issue.
book, my lord.
That is why many circle officer has
Yes.
gone to jail. Many Mondals
Jail.
gone to jail.
Blood
Sub
control
registers have gone to
certificates,
jail.
all are in jail. That is the case. And you are the mastermind and you are still in filing case.
Without the cooperation of the official authority, my lord, how, my lord, a layman, my lord?
That's why they have gone to jail.
Yes, my lord.
All
That is why they have enjoyed the fruit of their act.
They have already gone. They have already purchased.
Still did, my lord.
হ'ব নাই কেছ মিছি কিয় একো নহয় নাপায় নহয় য'ত পাবলৈ আছে মই তোমাক কৈ দিম যে এইটো পাবা পাবৰ লগত থাকিলে ময়ে কৈ দিম দিব নোৱাৰি তাতে মই কৈ থাকি কি
Pass the order, your petition is detected otherwise.
Should I submit the case there, my lord? Your lordship has
Yes,
already.
I have, but you can submit.
Yes.
Obliged.
এরকম episode দিয়েছো না?
31.
Yes, 32.
CD has been called for that.
Is received, I think.
FIR at page 9, lords. And Nicola at page 13, lords.
Well, in this case, KSRE received my lord, along with PM report, but PM report is my lord, not conclusive regarding the cause of death. So my FSL report will be required because there is also allegation that by consuming some intoxicating substance, my lord, there are my lord, offences registered under section 120B and 302 of the IPC, and from once there are my lord, 164 statement and 161 statement of the witnesses. All my lord, from all these statements, my lord, they implicated the present accused person. There is some my lord, illicit relationship between the present accused person and the my lord, wife of the deceased. That is the, and he also in fact admitted in his petition also my lord, the present petitioner admitted. And regarding those allegations also, there are some 164 statements, some 161 statement of the witnesses, and there is also some one audio clip regarding my lord, verbal conversation between the my lord, my lord, brother of the deceased and him, my lord, that was also provided to the police. So my lord, till now my lord, they are strong suspect. So FSL report will be required, considering the
This case is registered under 302 also.
302 also.
On what circumstance he died?
My lord died as because my lord, the informant was informed by the niece of the my lord informant that her father died out by taking some my lord. Your lordship may kindly come to page my lord.
Informant of brother, lords. Brother has stated as per his evidence, he heard from his younger brother, but said and lost after 29 days. He heard from his younger brother. Disease told the younger brother, then younger brother told his brother. By that way, he has evidence, not by the person who heard, he has not filed an FIR also. And after 29 days, allegation.
ভাড়াঘৰত পুৱতি নিশা প্ৰায় 4 বজাত দুটাই কিবা খাইছে আৰু নাই বুলি মোৰ ভতিজী তথা মোৰ ভাইটি খগেন বৰ্মনৰ ছোৱালী স্বয়ংসই মোক ফোনেৰে জনায়। দেউতাই কিবা খাইছে আৰু নাই।
Dad had been informed by daughter to her uncle.
So he,
But
Who died in fact?
yes.
Violina. Who died?
No, my lord, the Violina's father, my lord.
Violina?
Father, my lord.
informant brother.
Violina is the, my lord, daughter of the deceased.
Daughter of the deceased.
Yes.
Daughter informed her uncle. Uncle
Daughter Violina informed the informant, my lord.
informant, and informant got the information from his younger brother. Allegation is younger brother, deceased told her younger brother, and that has been statement said to the informant. Informant lost the affair.
So who Farid Ahmed is who is Farid Ahmed? He is
Farid Ahmed, my lord, there is some illicit relationship between the deceased wife and Farid Ahmed.
wife of
And in fact,
then
my lord, Farid Ahmed also, my lord, admitted in his petition itself. And there
Okay, now what to do? We need the postmortem. I mean, detail with call for the case. Only the FSL report. That will do.
See, if official report not coming the next day, loss, and then intel may be granted that there was.
My lord, at this stage, because my lord, because of these 164 statement and 161 of the witnesses, my lord, so that is difficult at this stage for granting any interim, my lord. After receipt of that toxicological report, if there is, my lord, nothing in that report, then can only be considered. Otherwise, from the from the statement of 164 and 161 statement, and because of the audio clip also, it is not possible, my lord. It is difficult, my lord, to say that there is no.
Okay.
33 also, my lord, same. He is the wife of the, my lord, the deceased.
Lordship, the matter may be passed over for the time being, Lordship, after break.
Same.
What is the timing?
Yes.
Why?
Same PS, my lord. Same. He is the, my lord.
1573.
98.
Connected. After time, sometime. You want time?
After break,
But
Lordship.
already 32 is fixed on 98. Same. Otherwise, my lord.
32 means same case.
Same, my lord.
Oh, it is 32 is already fixed on 9-8.
9-8.
It is out of same FIR, same case. So that will be fixed on 9-8. We are keeping the case diary, we are retaining the case diary till 9-8, and we are just calling for the FSL report. That much. You can intimate your also. Okay. Same order for 9-8.
No, and do it.
Please, your lordship. My lord, FIR is page 11, my lord. The 38 bail application.
Okay, just a second. We have received the case diary here.
34.
It's not showing this way. I'm asking. 38. Yes, FIR is that page?
Page 11, my lord. 34.
Oh, sorry, 34, yes. Page 11, yes.
My lord. My lord, allegation is that the accused person entered into the house of the informant without permission and he started hitting his father. And due to the hitting, my lord, his father injured seriously, and he took, my lord, he wounded, my lord. And he was referred to the hospital, and where his head was.
He is still alive or he died?
Alive, my lord. Alive. My lord, the petitioner is the accused number 2. Accused number 1 is the father-in-law of the petitioner, my lord. He was arrested, accused number 1. So, my lord, is a quarrel between the, my lord, the accused number 1 and the informant, my lord. And the petitioner, just because he is the son-in-law of accused number 1, his name, my lord, entangled in the, my lord, affair to pressurize this, my lord, the accused number 1, my lord. And on the day of incident, the petitioner was absent, my lord.
He was not present in
My
the
lord.
of occurrence.
My lord, para 6, my lord, is my old case, my lord. It's a land dispute matter, my lord.
Yes.
We have received the medical report also. That the nature of injury is grievous. Weapon used is dagger doubt, sharp weapon lordship, and he has received injury on his scalp lordship, that is 7 into 3 centimeters. Thereafter lordship, firstly he was referred to Goalpara CHC. Thereafter, for better treatment, he was taken to Solace Hospital lordship, Goalpara, where he undergone treatment lordship. And as per his own statement lordship, the statement of the victim, he has stated that this Akhirul Islam, the present petitioner, along with Zakir Hussain, trespassed into his house lordship, and thereafter this wound was inflicted. He became senseless, and thereafter his family members referred him to hospital lordship. As per his statement lordship, he has received around 15 stitches on his face. And lordship, regarding his presence lordship, there are other eyewitnesses also. They have all stated the same thing, that he was present. He, along with the other co-accused, assaulted him lordship. And lordship, before the court below lordship, they have preferred anticipatory bail. Their lordship, it was rejected. But lordship, one thing I found out lordship, that the informant side lordship, they have filed one objection wherein they have stated that their family members are harassing them lordship, threatening them to withdraw the case.
Still.
Yes, lordship. That is what I found in the order lordship. That is reflected in the order of the court below lordship. I will just point out lordship. Seen the written bail objection filed by the informant, petition number so and so, stating that the family members of the accused Akhirul Islam have threatened with dire consequences to the complainant as well as victim and other family members if the informant will not withdraw the case. Then he will kill the victim, informant, and other family members. So on that ground also, lordship, the bail was rejected after perusal of the case diary and the injury report.
Mr. and Islam, the learned counsel for
My lord, my humble submission before your lordship, my lord, since accused number 1 was arrested, my lord. So, my lord, further, my lord, interrogation, my lord, to the petitioner, custodial interrogation is not required, my lord, required.
as one is arrested, two interrogation for
Already arrested, my lord. So, my lord, is a my lord, is a my lord land dispute, the boundary land of their my lord house. Informant and the my lord, the accused number 1 are both adjacent house, my lord. So, my lord, petitioner, my lord, is just son-in-law. He reside in another village, my lord. Just because, my lord, in earlier 2-3 occasions, their dispute, my lord, they occurred, my lord. In that dispute, my lord, he settled the dispute as a mediator, my lord. And this time, my lord, his name came, my lord, just because, my lord, he was a mediator in earlier dispute. So, my lord, petitioner is, my lord, ready to, my lord, trial, my lord, sorry, my lord, ready to cooperate with the, my lord, investigation, my lord. And he is a local person, my lord. There is
Mr. Islam, the learned counsel for petitioner, and also Mr. B. Sharma, the learned additional duty appearing on behalf of state respondent. This is an application in section so and so in connection with so and so. Next, city dispute, there is the same hard dispute. It is submitted by next up that the present is innocent. It will be connected in the arrest. On the day of incident, also he was not present in the place of occurrence. However, his name has been inflicted in the FIR as he is the son-in-law of the accused number 1. And earlier in 2-3 occasions, he interfered in the matter and stood as a mediator. There is a land dispute between the parties, and out of which one altercation took place on the day of incident, wherein there was some and there was tussle between the parties, altercation and tussle between the parties, in absence of the present accused petitioner. However, he is ready and willing to cooperate the IO in further investigation of this case. privilege of pre-arrest. Mr. Sharma submitted in this regard that there are sufficient incriminating materials against the present accused petitioner, showing his direct involvement in the alleged offence, and from the statement made by the witnesses also it is seen that he was present of incident and assaulted the victim with sharp weapon like dove and knife, etc. More so, from the medical report, it is seen that the victim sustained grievous injury on his head and head and scalp region, which is considered to be grievous in nature by the doctor who examined him. Further, Mr. Sharma submitted that as per the statement made by the victim himself, it is seen that he sustained uh, he sustained he sustained head injury and 15 numbers of stitches had to be given to, to him. Initially, he was taken to Gwalpara CHC, but subsequently he was referred to Solace Hospital, Gwalpara, where he where he was treated. Mr. Sharma further submitted that from the rejection order passed by the learned trial court below also, it is seen that the present accused petitioner was present, and at this stage also he is harassing and pressurizing the victim to withdraw the case, to withdraw the case, first. Thus, accordingly, Mr. Sharma submitted that the accused petitioner, the present accused petitioner, is still threatening the victim and his family member with dire consequences. First. Mr. Sharma accordingly raised objection and submitting that this is not a fit case wherein the privilege of pre-arrest bail can be granted to the present accused petitioner. Next paragraph. Considering the submission made by the counsel for process, papers available in the case diary, injury report of the present accused petitioner vis-a-vis conduct of the present petitioner as reflected in the order passed by the Latin court below. I find it is not a fit case to extend the privilege of pre-arrest bail to the present accused petitioner. Accordingly, this stands rejected. Your petition stands rejected.
Highly obliged, Your Lordship.
May I please, Your Lordship? Lordship, it's a charge sheeted case, Lordship. The petition is filed under 438, seeking anticipatory bail. Lordship, the FIR, Lordship, will find at page, Lordship, 10, Annexure 1, Lordship. An FIR was lodged on 6/2/22, Lordship, alleging that on 6/2/22 at about 5 p.m. in the evening.
6/2 or 8/2?
It was lodged on 8/2, but the allegation, the incident is alleged to be of 6/2, Lordship. 6/2/22.
Yes.
The allegation here, Lordship, the daughter of the informant, Lordship, she was kidnapped by that accused FIR name, accused number 1, and thereafter, after her recovery, they came to learn that she was kept in the house of this petitioner. He is the accused number. The allegation against this petitioner in the FIR, Lordship, that he has sheltered that accused number 1 who kidnapped that girl, Lordship. That is the allegation.
So in the FIR, you are the accused number
2.
Nadu Sheikh.
Nadu Sheikh.
In your house, the girl and the other accused was
The girl was 18, above 18 years old. She eloped with that accused number 1, and they stayed for one night in my.
one night they stayed in my house and then thereafter they left. And even in the charge sheet also it is mentioned the same thing, Lordship. And she were having a love affair with that boy, Lordship, with accused number 1. Because that boy is known to me, Lordship, and I allowed them to stay for they sought for in the evening they came and they sought for shelter, so I allowed them. Lordship. And then the next day they left, Lordship. But subsequently, I think the girl was not married by that person, Lordship, so they lost that case. And during the investigation, Lordship, I was never sought. My presence was never sought by the investigating officer, so I was not aware, Lordship. So only after receiving the summons, Lordship, from the court, the case is in Udalguri, Lordship. I hail from Dorong district, Lordship. So after receiving the summons, Lordship, I came to know that there is a case, and after making an inquiry, Lordship, I could learn, Lordship. So my apprehension now, Lordship, now if I appear before the the jurisdictional magistrate, Lordship, because the case is triable by the session, Lordship, so I will not be granted bail, Lordship. So I am ready to face the trial, Lordship.
Lordship, here the incident, as Lordship has already seen, is of 6/2/2022. 2022, Lordship. And Lordship, the charge sheet was laid on 28th of February 2022. 20th February. And Lordship, under section 366, 376, and 34. Then, Lordship, the 164 I have gone through, Lordship, it implicates the present petitioner also. Now, Lordship, regarding his submission, Lordship, that the police never sought his attendance, Lordship, that is absolutely false, Lordship, because in the scan copy, Lordship, I have already found one search list. His house was searched. There are witnesses also, Lordship. On 15/2/22, that his house was searched, he was found absconding. Now, Lordship, since 2022, he is absconding. And Lordship, in the meantime, cognizance was taken on 6/12/22. 6/12/22, cognizance was taken under the same section, 366, 376, and 34. And after Lordship, repeated summons were issued to him. He failed to appear, Lordship. Ultimately, Lordship, on 8/7/24, bailable warrant of arrest was issued of ₹5,000 against them, Lordship. And in the meantime, Lordship, in between, Lordship, the bailers were also asked to appear personally before the court. They appeared on one day, thereafter they also not appeared. But that has no relevance, Lordship.
Because he is shown as
an absconder, Lordship.
Yes, yes. So, Lordship, the conduct of the petitioner, that regarding the incident, Lordship, from 6/2/2022, he is absconding. He was not present throughout the investigation. After charge sheet also, Lordship, court has repeatedly issued him summons. He is failing to appear before the court below, Lordship. So at this stage, Lordship, anticipatory bail cannot be granted because, Lordship, otherwise this is a very bad precedent, Lordship. Throughout the investigation, you will even abstain. After 2-3 years, you come with an anticipatory bail. That cannot be allowed, Lordship. Let him appear before the court below, Lordship, with a bail application. It will be considered merit.
Lordship, if Lordship will go by the case record, Lordship, someone was never served on me, Lordship. And regarding that bail, Lordship, when I'm an absconder, I have from where that bail.
That is okay. Okay.
What about the Lordship, the charge list?
But the question is that how can you come to know then now?
Yes.
You have not received any summons?
No. Subsequently, I have received, Lordship. Yes, 10/10/6. I have made a statement, Lordship.
Okay. Mr. Petition, and also had Mr. Bishop done an additional copy appearing on behalf of state respondent. This is an application and a section so and so in connection with so and so. Scan copy of the case record has already been on the case record. There is the state hard copy. Submitted by Mr. Amit Tikare for the petitioner that the present petitioner is innocent and he is no way involved in alleged offense. It is the fact that the victim and the accused number 1 came to his house and he gave shelter to them, only sheltered him and staying one night in his house. They left his house and thereafter he did not aware about the lodging of any FIR against the lodging of any FIR in connection with the same incident. During the investigation, police never searched for him, and hence he is not aware of any pendency of the case against him in any police station. Most incident have occurred. No, incident. Most of the FIR is lost. FIR, where is the FIR is lost there?
It is lost in Kalagaon police station, Lordship, under Udalguri
Dorong,
district.
and
No,
you
it's in
are
Udalguri district.
Udalguri, and
Under
you are in
Udalguri.
Dorong.
Yes, I hail from them.
That the case is already was registered under Kalagaon PS in Dorong in Udalguri district. So the present petitioner is a resident of Dorong district, and as such he was not aware about the case. However, he is ready and fit to appear before the Rana trial court below, and will face the trial if he is granted with the privilege of pre-arrest bail. Next paragraph. Mr. Sharma, the learned additional victim, submitted in this regard that from the case record is that it is seen that there are sufficient incriminating metrics against the present accused petitioner also, and also, and the present, and he submitted that the FIR was lost on 6 to FIR was lost on 8 to 2022 for the incident which had happened on 6 to 2022. And the cognizance of the case and the FIR was and the FIR and its charge sheet was filed on 28 to 2022. The learned court below took cognizance of the case on 6/12/2000. Cognizance was taken when?
6/12/2022.
Cognizance.
Yes.
Cognizance was taken on 6/12/2022. He further submitted, Mr. Sharma further submitted that from the CD it is available that his house was searched during the investigation on 15 to 2022 and another occasion also, where he was found absconded and he could not be apprehended in connection with this case. Accordingly, it is seen from the record that the accused is absconding since 2022, and the learned court below had issued summons in several occasions, but thereafter he issued bailable warrant on 6/12/2024. 22. Just a second. He issued bailable warrant on which date?
Okay, bailable one was never issued.
Issued, Lordship, on 8/7/24.
8/7/24. And the complaint says finally the learned trial court below had issued bailable warrant on 8/7/24. Mr. Shah accordingly submitted that considering the entire conduct of the accused who was absconding since last 2022, his bail may not be his prayer for anticipatory bail may not be considered. However, he may be directed to appear before the learned trial court below with an appropriate for bail, which may be considered in accordance. By the learned counsel, I have also filled this kind copy of the case recorded of the case diary, and it is seen that the implementing methods are already been collected by him. And at the same time, it is seen that there was a house search for the present accused petitioner, but he never cooperated in the investigation and was found absconding during the investigation. More so, even after filing of the charge and an instance of repeated summons, he is still absconding, and the present petition has been filed after a long 2 years later. 2 years later for a prayer for bail. So considering the conduct of the petition and the effort made by the trial court given. I depicted the privilege of to the present accused petitioner. However, the present accused petitioner may be directed to appear before the learned trial court below with an appropriate application for bail, which may be considered in accordance with law, and till 10 days from the date of order. No, he has to appear. It's only bail, which may be considered in accordance with the option the present may be sensitive. You are only directed to appear before the learned trial court.
That bailable warrant I could not find in the order sheet, Lordship, because that date because only summons were issued and summons were never received, and
okay, it's okay then.
it continued.
If someone is all issued, it's good only for you. If warrant is already it's not there against you, it's good only.
Bailable one 10,000 against 8724.
87,2024.
But after that also fresh summons every time. Issue fresh summons to the
87 is the last order.
after that again summons issued against the accused does not return, issue fresh summons.
After 87?
Yes.
Lordship can skip that line if he has some so many problems.
87. Just let us see. Your confusion.
It will be difficult to find out. Into line.
After 87, what is the after 8724, what is the name?
Because cognizance was taken
No,
on
after
6/12.
87, what is the next date?
8 you call up 8/7
After 87 2024, what is the next date fixed?
or 8/7 Lordship.
8724, what is the next date fixed?
8/7 I don't have that 8/7 order Lordship here.
We are talking about 87 only. Because that's
No, he said 8/7/22 Lordship.
no, we are saying on 87 2024. On that day, your available warrant was
Yeah, 2024.
thereafter the date is
That is
there.
after filing of this bill application.
Huh?
Because I have the orders up to 10/5/24.
10/5/24.
Yes.
This is subsequent Lordship. He has not annexed this anymore.
10/5.
8/7 recently.
10/5 is not there. 9/5/24 is there. Then 10/6/24 is
Yes, 9/5.
9/5, 10/6. Thereafter 87.
10/6 up to 10/6.
Oh, you have up to 10/6.
Yes.
But it is service is returned after service. That's why available warrant was.
Yes.
My lord, I don't know, 37th that I have been told that my series.
Yes. Lordship, they are already on interim. The PM report is not available. So Lordship will have
What
to-
is not available? CD is not available.
PM report.
Otherwise, CD is available.
Yes, yes. And they are already on interim Lordship.
Yes, on objection was filed.
Yes.
You have filed objection.
Yes. We got the copy, ma'am.
We tried to get it by affidavit. Now you have filed already, na?
Yes.
So we have already received this one.
Yes.
It is already received, so we can hear it at 2 or any other subject.
Lordship, because ultimately the PM report will be required Lordship, because allegation of 302 is there. So
Oh, you have
PM,
not received the PM.
yes, the PM report is not available.
Mr. Teacher, 4037. That will be tested by MS. MS, his name is not there. Ardeka, counsel for the petition. And also for Mr. You are Mr.
Mr. B.J. Daka on behalf of Mr. A. sir. My name is not
Also for Mr.
on behalf of Mr. A. sir.
Respondent number and card Mr. P. Sharma.
Confirm to the
Done it additional PPF. It is submitted by Mr. Deka for the counsel for respondent that we have already filed. Yeah, we have filed
Affidavit in office.
yeah.
Already on record.
Is already
Yes.
however it is subject to private report not read as it of report will be. You want to return back or
We'll update it, look.
update it?
We'll update it.
Accordingly, CPP return call for it to the case very allow it to be report. When it can be distributed,
Lordship,
if you return, then it will take some time.
it is 22nd, 8, 22, 8.
22nd of August.
Yes.
Interim in both the cases.
Interim was there.
Yes.
Yes, Lordship.
In both the cases,
Two cases, 37, 38.
37, 38.
Out of same
37,
here.
38, same.
Same.
37, 38. In both the cases, interim was there.
Yes.
Interim be completed.
Obliged.
Subject to what PP has got to say.
Yes.
May I please, my lord? My lord, I have received the CD, my lord, and the status, my lord. However, my lord, I could not send it to Guwahati, the scan copy, my lord, because it is a voluminous CD, as my lord is well aware of the case, my lord. And as per my instruction, my lord, the charge sheet has not been filed, my lord. The investigation is still going on. It is almost completed, but then we have not yet filed the charge sheet, my lord. So I don't have much to object upon that, as my lord is well aware of the law, and my lawyer has already advised my lord the Rakesh Paul case, my lord.
So investigation is still going. Investigation is still going on.
Yes, my lord.
So, my lord, the relevant paragraph, because in the Bikramjit Singh case, the citation is 2020, volume 10 SCC, 2020,
Yes.
volume 10 SCC.
Yes.
The relevant page is, in fact, the judgment begins at page, I'm sorry, at page 616. The author of the judgment is Justice Nariman, and the relevant paragraph is paragraph 33. Wherein relying upon the ratio in the Rakesh Paul's case, the Supreme Court says that even the oral application is good enough. Once the bail application is filed, before much before, and in the meantime, the 90 days period is over, then the oral submission is good enough. The oral application will do. I just read, not the relevant sentence. In a fairly recent judgment, I am reading from para 33. In a fairly recent judgment, reported as Rakesh Kumar Paul versus District of Assam, a 3-judge bench of this court referred to the earlier decision of this court and went one step further. It was held by the majority judgment of Madan B. Lokur J. and Deepak Gupta J. that even an oral application for grant of default bail would suffice. And so long as such application is made before the charge sheet is filed, that is it, my lord. So that is it.
Today is 91st day, or?
I beg your pardon?
Today is
91st day, because my lord, the arrest, the prisoner was arrested on 1st May 2024, after my lord rejected the bail application. Thereafter, he was arrested on 1st May 2024. So thereafter, my lord, for 15 days, he was in police custody. And so far as judicial custody is concerned, he has already spent 76 days in judicial custody. 15 days in police custody, 76 days in judicial custody. Total period of custody is below 91 days as on today.
92 days.
92.
92.
92, very well. 92, I said corrected. 92 days. So that is it. The consequences follow.
Mr. Pada, we have, we have already, I have already perused the case diary earlier.
Yes, madam.
Bail plan. So my earlier order, mostly there are some reflection. So I'll
Yes.
go by that, and because CD is not available before me at present. However, as far as there are materials collected by the IO, as far as the investigation is concerned. But yes, 90 days already invested, so definitely that's what.
My lord. So, my lord, I take it that my lord will pass in on the granting him bail.
Yes, yes.
That is it. Obliged, highly obliged.
All right.
So, from that, the case from Vidananda Bank that for a case considering the intimidating materials and all in the case diary, and that before they preferred an SLP motion before the Honorable Supreme Court that has been rejected and asking him to surrender before this court. And accordingly, he surrendered on 1/5. But see, the progress of the investigation, what to say? Even after 92 days, they are not in a position to file the case charge. That this need to record that 2020 number to look at 2020 10 this one. So we have remanded the case record for the learned member MSCT with a direction to also to issue a press issue on that regard, whether DL was valid or not at that point of time. And within and we'll try within 3 months, the date of passing the judgment and order, the exercise has to be carried out to dispose of the matter. And so far as the case of another MSc was there, MSc 377. Here, it is here. MSc 377. What had happened in MSc 370, as the other matter is already been remanded back, so we'll be not in a position to pass the order. It is kept in abeyance. As soon as this one, the ST will immediately publish.
That's one thing only, because in the tribunal, we are also a party in the matter. So we may also be allowed to adduce evidence, as a claimant, because both the parties should be allowed to adduce evidence. To that extent, my
in that said case also.
Yes, Milord.
Okay, and I can.
To that extent.
Okay. That yeah, I have not signed it. That can be.
Then also, because they already examined witness. DTO was also examined, so we may be allowed to cross-examine them.
Obviously, you are allowed. You are allowed to cross-examine those the DW. That is the specifically the DTO officer or that was there. Right? And apart from the, if they
and also I can adduce evidence.
Yes, and
all the parties
they
can
want,
adduce
then you can also cross-examine.
For
particular that extent only.
On license.
To the other side, you want to adduce evidence
Milord, yes, Lord. From the claimant,
that cannot be allowed. That cannot be allowed.
Then no need
to most
no need.
And you can what I have said, that after disposal of the case by the learned member MCT, definitely it will come before us, and that in that regard, regarding the enhancement part, will be definitely. This MFS stands dismissed. Dismissed. Criminal revision petition stands dismissed. This civil revision petition also stands dismissed. There also in the result, I don't find any merit in the petition. Accordingly, it stands.
Okay.
It's within petition. Yes, 20.
May I please, Your Lordship?
Yes.
My Lord, here on the earlier occasion, my Lord, we made a prayer that we will file an additional affidavit because whatever documents we had regarding completion of job, my Lord, we did not provide it to the police because by that time the case was registered, we deposited to my senior officer, my Lord, the DFO concerned, Pathakandi Division, my Lord. Here, what has happened, my Lord, Lordship would kindly look at the FIR. One line I will show, my Lord. FIR, page 14, my Lord, with all respect, my Lord. The DFO has lost the FIR, my Lord. Lordship has seen page 14. I'm sorry, my Lord. Page 14, my Lord. There, if I read it in totality, my Lord, which is, my Lord, leaving aside 5 lines from the top, my Lord, which is financial irregularities and misappropriation of public money, hence as directed by the higher authority. Have I made my position clear, my Lord? And in the additional affidavit, my Lord, this same DFO has given a certificate, my Lord, with all respect, my Lord, I'll place that, my Lord, huge bunch of papers because I deposited it to the Divisional Forest Officer's office, my Lord. When police asked me to deposit the papers to them, my Lord, I could not because the case was registered. Have I made my position clear, my Lord? And now in the form of additional affidavit that I have collected Xerox copies from the DFO's office, my Lord. And DFO has provided me with all those papers, my Lord. It's a huge bunch of papers. Therein, Lordship would kindly see page 20. My Lord, I'm placing it, my Lord, with all respect, my Lord. So, Lordship would kindly have a look in the additional affidavit, my Lord. Page 26. Huge one, voluminous one, my Lord. Dear Lordship would kindly have a look at page 26, my Lord. बहुत खकर page 26, my Lord. I read the FIR, my Lord. They are reading the DFO has said, as directed by my higher up, I lost this FIR, my Lord. With all respect, my Lord, I read it out, my Lord. Here, my Lord, this is my letter to the DFO, my Lord. With all respect, my Lord. This reference is pointless, my Lord. Sir, with reference to the subject cited above, I have the honor to submit here with the progress report of utilization certificate, along with whatever it, my Lord, photographs, etc. of so and so of plantation and the camp scheme during the year 22-23. Same scheme is reflected in the first information report, my Lord. Thereafter, my Lord, with all respect, my Lord, Lordship would kindly have a look at page 31, my Lord. Page 31, my Lord. It begins from page 31, my Lord. At the top, through contractor, thereafter, my Lord, through department. This is the head note in the FIR, my Lord. Campa 23-24, as on so and so. Thereafter, let me turn the page, my Lord. Next page, my Lord, 32, my Lord. 32. Lordship has found, my Lord. Right at the top, my Lord, chronologically, location. I lead the FIR thereafter, my lord. Panighat area Tirbhum RF under Patherkandi range, my lord. Lordship has found, my lord. The same range is reflected in the first information report, my lord. Thereafter, my lord, physical progress 60%. I could not annex it at that point of time when I filed a PRS bail application, my lord. That, my lord, it would be there in the CD. With all respect, my lord. Now I have collected it from the DFO's office and I have filed it, my lord. The report is, my lord, physical progress 60%. Weeding work and vacancy fill-up is going on. This is by the same DFO, my lord. Divisional Forest Office, Karimganj Division, Karimganj. Lordship has found, my lord. And thereafter, my lord, page 33, my lord. As because the first lot of money was spent, 50% was spent, 50% of the money allotted, my lord, 60% job was carried out as per DFO's report. Thereafter, my lord, I have written this letter, page 33, and therein it has been stated, my lord, to release the next amount of fund. I'm just reading it, my lord. With reference to the above, I have it goes on and on, my lord. Thereafter, second year maintenance and vacancy filling, rupees 42 lakh so and so, but you have released only 21,056,000,000. And that amount, my lord, is reflected in the DFO certificate, my lord, and tallies with the first information report, my lord. This is my case, my lord. And this was not seized by the police from the DFO's office. I may be provided a chance to provide these papers so that the truth comes out. If the papers are not genuine, my lord, I'll have to face the consequences, my lord. I deposited it not to the police because the papers were submitted to the DFO's office, my lord. Prior to the FIR being lost, my lord. An FIR was lost by the same DFO at the behest of, my lord. That line again I'm reading out, my lord, with all respect, my lord. Same DFO has given the certificate that 60% of the job is complete, my lord. And now he lodges the FIR, which is financial irregularities, hence as directed by the higher authority. This is my case, my lord. I do not know what is there in the CD, my lord. Relevant pages, my lord, with all respect, my lord, of the additional affidavit. Page 26 is our letter, my lord, and DFO certificate is at page 32 of the additional affidavit, my lord. And page 33 is my letter after 60% completion of job, my lord, with all respect, my lord, for regarding release of the rest of the amount that has not been released and I have not utilized, my lord. So my job is as regards the 50% money, and that to 60% job has been completed. Certificate has been given by the same DFO. Unluckily, my lord, I deposited it to the DFO's office. I could not provide it to the police because the case was registered. And without, my lord, with all respect, my lord, an order from this court, my lord, I cannot appear, my lord. That was my position at that point of time, my lord. The rest I leave it to your lordships.
My lord, is there is received, my lord? Now, during the course of, my lord, investigation, the IO made certain queries to the DFO by addressing letter, but whether the account is government account, who is the authorized signatories, all these things are certain questions. Now, so far account is concerned, Lord, yes, the account is a government account and the petitioner is the authorized signatory. Now, only the allegation is, Lord, on 7 occasions, he withdrew the amount on sale 6. Now, subsequently, another letter was issued by the IO to the DFO asking for certain questions like whether any progress report, expenditure report of work done by Forest Ranger Manoj Kumar Das, the petitioner, under the LS campus scheme is submitted. If yes, kindly provide it along with enclosed document. Whether any inspection is done by the authority while the work of 50 hectare AR and ANR plantation was doing on under Ranger Manoj Kumar Das. If yes, kindly provide the report.
Now a report has been submitted. Inspection report is there. As per inspection report, the members are examined, my lord. They say per hectare there should be 2,500 samplings.
Gauss pulley, my lord.
Gauss pulley. Then they found on verification less than that. No, there may be different reasons of
My lord,
that.
some plants, my lord, when planted, they do not survive even for 7 days, my lord. That is why the DFO's report, let me complete, my lord.
So
That'd be better.
that is there. That is their finding. And they simply says that we did not find up to 2,500 per hectare. Now, so far this regarding expenditure, utilization of the fund, the DFO has given a reply to the IO. I'll submit the case there in a minute. The cash account of CAMPA of the aforementioned, this is DFO's letter to the IO. Work is only the expenditure report submitted by Manoj Kumar Das for a stranger. However, it was returned to RO Pathargandhi on 25/8/23 due to multiple anomalies and procedural lapses identified in the cash account. Now, they have perhaps returned, but that is why this is not part of the, these documents are not part of the case diary. Now he has submitted these things before this honorable court. So let him submit before the IO, they will verify whether
Yes,
the expenditure is up to the whether there is any anomalies in respect of. It is admitted position that petitioner withdrew the money, and he has given certain explanations regarding expenditure. Now, whether that is acceptable or not, this
This can be solved in this manner, my lord, with all respect, my lord. If my friend agrees, my lord. If I have defalcated, my lord. No, I'm not saying that, my lord. I'm not saying that, my lord. The papers which I have submitted, my lord, same DFO testifies, my lord, 60% job is done. Now he says, my lord, at the behest of higher ups, my lord, he lodges the affair. Let me submit my papers, my lord, which I deposited to the DFO before the investigating officer. Let them verify whether the papers are genuine or not, my lord. If genuine, there is no case, my lord. Kindly, otherwise, my lord, how can I go without an order from this court before the investigating officer, my lord? Let the truth come out, my lord. If I have done something wrong, my lord, with all respect, my lord, let it be rejected on the next day, my lord. That may be written in the order, my lord. Let me place all these papers before the investigating officer, which I submitted to the DFO, along with the DFO certificate, my lord. He cannot nullify it, my lord. And kindly see, my lord, the remark portion, weeding is going on. Gospuli Rupon Kajjo Husi, my lord. 90% plants are dead, my lord. Have I made my position clear, my lord? Because it would be verified after the case, my lord, 2-3 months subsequently, my lord. So let me supply the papers before the investigating officer, as he has suggested, my lord. I cannot go without an order from this court. Let a date be fixed with an up-to-date case diary, my lord. Absolutely up-to-date, my lord. And if anomalies are found, yes, lordship is at liberty to reject it, my lord. I'll go to jail, my lord. These are my papers. I submitted to the DFO. I could not submit it to the investigating officer because thereafter the case was lost, my lord.
Some photographs are also collected regarding
we have annexed everything, my lord. All photographs and bills and everything, my lord. Lordship, kindly, the subject of dispute is, my lord, same DFO, my lord, at page 33, 60% job is done. Thereafter, he lodges the affair. Dates are, my lord, the certificate is prior when, my lord. The FIR is subsequent, my lord. And in the FIR, it is stated at the direction of higher ups, my lord.
My lord, that letter is also there, my lord, from government, my lord, to lodge an FIR. My learned friend says that at the instruction of under secretary, yes, on letter is also collected by the IO. My lord.
My lord, I think with all respect, my lord, genuine prayer, my lord, entire materials also would reject it, my lord.
but 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 the court but that that the court there are other some other that there and also that for 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 that are one here for same it that out by after by after but that context subject that was by bringing all record that has come it has it has no enough for but but no had no scope with all and there as there was a the, but if it is given one and hope and it uh but that there will something at and when one way authorize is the authorized
One answer is also there. Well, the IO asked the question whether any departmental proceeding has been drawn against him or not. The DFO has replied, well, till now, well, no departmental proceeding has been initiated against him. That is also there.
but 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 and operate of but operating it but not up it and uh but it or other and for but sure. That's what done effective and good of what trade but but did the uh but and open all for the updated appeared to be I and produce all this because it is the key that yeah earlier submitted all this with the
DFO, my lord.
DFO,
that
yeah.
was not considered or
My lord.
on the instruction of the higher process.
Yeah,
So they can when can be updated possibly is there
অলপ লম্বা দিব স্যার গোটেইখিনি দিতে ডেটা কৰিব
Well, he has to verify all these documents
yes
also
all
regarding.
and I they did it upon
On 2nd of September.
to appear before they have been already been
My-
people get the chance to verify on
my lord, my lord, my lord. My lord, Lordship has granted me interim, my lord.
interim.
Highly obliged, my lord. Obliged, my lord. Obliged, obliged. My lord, I am to appear within 7 days, my lord. Highly obliged, my lord. Obliged, my lord. Obliged, obliged, my lord.
May I please show?
Yes. So we have received your additional.
Yes, they are clearly mentioned in the FIR. It has been mentioned, my lord, in the line number 3. 2 persons were illegally and forcefully demanding money in the name of Bonso. So there is a Bonso certificate in the page number 1414. The arrested are the members of the Bonso. They are,
Yeah, also.
yeah, Bodo National Student Union member. And secondly, in the affidavit which has been reflected by the proprietor of the store, it is written in the FIR line 6 number, from the shops at BB Paradise Point. That is the shop from where the leasing that they have collected the money. But here the owner of the shop says clearly stated in the FIR that in the affidavit 345 in the serial number that I am the page number 24, my lord. I am the owner of the BB Paradise Point. That is the name of the shop. Serial number 4, that aforesaid persons were not demanding any money from me. 5th, I have never given or payment monthly basis money to any other person. That means it's very clear. It is the only, it was a political mileage, political motivated allegations. And I have been already last 44 days in the custody.
Is gone on to which day?
22nd of July. 22nd of July.
Out of fear, he
No, my lord, no. They are already, they know each other. They are very acquainted to each other. They are all local people.
CD not available.
So CD, this is the 3rd time consecutively.
No, not third time, second time.
No, the 3rd time on 17th. You see. On 17th, also CD was called on 25th, and today is the 31st. And they are moreover student, my lord.
other check is placed at
Extortion
386.
386 oblique 35 IPC.
Yes,
No reason also given. Why is it not given? That is there.
now these 2 persons are from Bongso organization.
Yeah, they are the students. They are the member of the Bonso. And allegation is that they are demanding money or they have extorted money. In reality, they have not demanded any money.
This petition, this FIR was filed
By the inspector,
inspector.
not by the any independent person, and there is no independent witness, my lord. It's a mere allegations, my lord. Just to harass, just to shut the mouth of the Bonso students. Because they are the rival groups of the ruling government.
40 days.
And my lord, we are going to follow all the term and condition, whatever this honorable court impose upon us. There's no chance of us responding or any threatening because permanently we are resident of that particular elekas.
So you are behind the first is 21 6.
Yes, my lord.
40 days.
June 44 days. 42 days months. On 21st June, we were arrested. Until that, we are in the custody.
During that period, are you ever in the police demand? No. Whether police demand was there? No.
No.
That may be mentioned that CD not received. We have sent signal on 77 also, but no reason given. Why not given?
Our duty. My lord, too.
method of box or full form Bodo.
Bodo National Student Union.
Bodo. And computer. But but as your of the subject that from whom that is one was when what is that not by the by when uh but the but that one and the and but that I have that the made of it but not the same in but there was a demand that party but that part can be
Well,
but not get the from Kokra.
Compressor, Cesium
compressor.
Okay.
develop.
Yes.
Apparently, where please the lordship.
But we have received it.
Received lordship.
Lordship, here, lordship, kindly come into page 7. This is affair with the lordship.
Page 7.
7 lordship and 11. Starting page 8 lordship. No.
There is something wrong.
So we are on 36 AB 1728. Who is the pen?
1728, I am Miller.
You are
Yes. My landlord was pushing me. Annexer 1 Miller, can you see me, Lord? Annexer 1. Before he starts, just one thing, here the case is registered under 325 and 307. Lordship, admittedly, there was an assault, Lordship, on the victim. So far, Lordship, the victim is concerned, Lordship, the medical report, initial medical report is before your Lordship. Here, Lordship, he has suffered one fracture in the eye, Lordship, here. And also his legs swelling and something else is there, Lordship, in the legs. Subsequently, Lordship, he was referred to another hospital, Lordship, in a private hospital where it is stated that he is undergoing treatment. So, Lordship, in after Lordship going to the case day, Lordship, that report will be necessary, Lordship, to know the extent of injury which he has suffered, Lordship. Because presently it is stated that he is undergoing treatment at private nursing home in Bongaigaon. And Lordship, the injury that he has suffered, Lordship, for that he has been referred to Department of Orthopedics as well as eye injuries there. So he was referred to the eye department also, Lordship. So that report will be necessary, Lordship.
And medical report was last minute medical report was free after CD and medical report was what?
No, one medical
CD
report
is
is here,
there.
Lordship. Medical
And
report
medical
is here,
report-
Lordship. Initial medical report is there. But subsequently he was referred to a private hospital. If Lordship kindly goes to the medical.
That is what you want to say. Will we keep the case record? Retain the case record?
I can take the medical report to WhatsApp also, Lordship. That's not a problem. No.
In that case, your petition we can fix it on next week also.
No.
Otherwise, if you return back case there, then it may
Yes, it will take
be
time.
delayed. That's why we retaining case there. Let us call for the present
After medical report. madam.
Yes,
medical report. It will take it and
Yes,
call for it.
Then we shorten we will see long pending case.
That's what we are saying.
In the month of June, it is started. Anyway,
Month of June.
the SR was filed in the month of June, madam. June, July, 2 months. Back.
Uh, but it, but that's why. But all for but that that call for or opt-in, call for opt-in. That I on yes when it
Lordship, 7 or 8, Lordship.
yes 7
Man, 7, 8,
Next
7,
week.
7, 8, okay.
7 7 but it did not come.
Right.
It will the Lordship. In this case, Lordship, CD was called for and interim was granted to the father and mother, Lordship. FIR was by the daughter-in-law, Lordship.
CD received, Malad, but 164 is also available, but medical report was sent for medical, Malad, her medical examination. 376 is also there.
Lordship,
That
kindly see
medical
the
examination
FIR.
is not.
This is by whom? In fact, this is that.
Brother-in-law,
No,
Lordship.
elder brother and younger
Younger
brother of the husband.
These are completely false
This is
allegation,
brother-in-law.
Lordship.
And against husband, what is the
Husband, not much. Malad, I have gone through the
no,
164.
against the husband case is also registered against
Yes,
the
yes,
husband
yes. There are husband.
Petitioner number 1 is the husband.
Was in the husband, 2, 3 brother and younger brother, elder brother, 4, 5 other father and mother. 4, 5 already interim granted their appear mother. And the
and
husband,
1 to 3 or 1 is the husband,
One is the
20 are
husband.
brother-in-law.
Lordship,
Yes.
completely false allegation. Lordship, kindly go through the
I
FIR,
mean,
Lordship.
it's okay. If it is supposed as per the
as per,
FIR,
yes, as per the FIR, and as per 164 also, there are allegation of torture and regarding demanding dowry. But fact is that as per 164, clearly stated that other members of the family, they are separately living with husband in separate room, and one day when husband was not there, these two brothers raped her. There is the allegation 164. But regarding dowry, not much things is not much. 4 and 5 already in interim. I have nothing to say against them. 4 and 5. Father and mother, they may be absolute. But regarding this 2 and 3, 164 there are materials, but medical report is not available.
go by case study because she is a married woman. It's not much revealed with the medical report because
164.
suppose that
Yes,
these things that they think not will come the report or
Yes, yes,
so
but-
she is a married woman. But however, is there any, any injury, etc.? Is there that comes definitely? But what is your other method?
Other materials are clear. It's clear. My lord, may peruse the 164. 164 is very clear regarding my lord.
Lordship, there was a dispute fighting in between husband and wife, Lordship. Out of that, the entire matter, Lordship, started. Para 5, I have stated, Lordship.
But as per 164,
These are all false allegations. There is a dispute fighting between husband and wife. She called her brother, you come and took me from this house, and thereafter misunderstanding done, Lordship. But the brother came and took her away, Lordship. That after some days I will return her to your house, saying that. But later on they instead registered the affair, Lordship.
Why he brought such a nasty?
So, Lordship, there is nothing in regard to 498A. So, Lordship, to make some more allegation, Lordship, 2 and 3, whether it is believable, Lordship, eldest brother-in-law and younger brother-in-law together, Lordship, whether it is believable, Lordship. It's not normal, Lordship, in fact.
As per the statement, fact is that there is a demand of dowry of 5 lakh, and it's about not 3 months not completed of marriage, my lord. And until and unless that money is paid, my lord, they are not allowed to living with the husband. She is not allowed to living with the husband. Husband is living separately. And on one day, my lord, when husband was not there, these 2 brothers committed rape upon her, and again, my lord, torturing by the all the family members, my lord, that is there. And next day, brother came and took her. So 164 is clear, my lord.
Lordship, 164 is to some extent different, as because the FIR first 4-5 lines here, Lordship, kindly go through FIR, Lordship.
With
Page 14, Lordship, vernacular, Lordship. There she stated that her husband is not allowing. And here, Lordship, as per my learned friend's submission, Lordship, the family members are not allowing her to stay with her husband, Lordship. First 4-5 lines, Lordship, Bibahor Kisudin Kisore Pora, Lordship.
Husband also there.
So here in the affair, she is saying, husband is saying. Completely false allegation, Lordship. In para 5, I have stated, Lordship, there is a family misunderstanding took place between the husband and wife, and out of sentiment, the informant called her brothers to come and take her back to her paternal house. However, their misunderstanding was removed soon, but in the meantime, the brothers of the informant came and started quarreling with the accused person and scolded all the petitioners, and eventually they took the informant to her paternal house, Lordship. Though the marriage was socially, but out of love, Lordship, that marriage was took place. So brothers were against this marriage, Lordship. So all the allegations, Lordship, 498A, 376, everything was given in the affair, Lordship.
whether the other record.
The statement is not available. Otherwise, their bail bonds are available. Note of the on other yes, witnesses are there.
If the police is investigating, Lordship, my father and mother appeared. They did not take any statement from my father and mother, Lordship. No statement was taken from my father.
Note of the I was there.
At least to some extent, they could investigate through parents of the Lordship petitioner number 1. these are all family members.
Family
Any
member.
other independent witness? No.
Who independent I have not found.
That other difficult.
But one,
20.
yes, regarding 20, otherwise husband also not, I am not opposing against
But
the
Lordship
husband.
kindly say the allegation
But,
date of incident 7/6 and FIR was lost on 14/6. Whether it is believable, Lordship. If such
she-
an offense was done to her, Lordship, she would have immediately gone to the hospital and
she
Lordship.
said out of fear,
No, she was taken to her home on 8/6 as per FIR. If she is at her own house, Lordship, where is the fear, Lordship? There is no apprehension. We are not going to threaten her at her own house, Lordship. These are completely false allegations, Lordship. Regarding in FIR?
চিকিৎসাত ব্যস্ত থকাৰ লগতে গাঁৱৰ দিৱানীবিলাকে গোচৰ দিয়াত মানা কৰি থকা ডিজাৰ্টেড পলম
So, Lordship,
they are trying to give village mail and all.
Devani, why Devani with means because she is in her own Devani. Yes, obviously Devani play a very vital role in that. I heard one instances where body gave a person the book. A scene of or even a evidence of rape did back but that was there Devani. But she was, as per FIR, Lordship, she was immediately taken to her home, Lordship. Right order. Right. Then, that. But the that but after the on it, but that of or 14/6, Lordship.
But 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 that that by or it uh, pro- of it that that from apart from uh, 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 but that but apart from and what type of of it like that one type of that 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 I it it is that and one that that it record for us of fewer than it
Lordship, I am deeply obliged.
but they also
Lord.
For P1, I am sorry, my lord. CD not received.
My lord, in this
I
case,
one
lordship,
in
no lordship,
no,
and
not
two
one.
occasions already with lordship for CD. And lordship, in this case, lordship, the petitioner is petition number 2 already been arrested, lordship.
Allegations are also serious, my lord. In police
And
dress,
but my lord,
some
here this case,
7
lordship,
person came at around night around 12:50, and in the name of searching, they looted the
no,
whole
they are
ornaments.
not lordship.
And all
They are
this.
the boatsmen.
That is the allegation in the FIR. and this petition, one petitioner is both men.
And Lordship, actually, there is the paragraph
Petitioner number 2 is already
arrested. Okay, that is another question.
but not a case of interim. I think they have
Two occasions, we have 12 and 22, we have sent the signal, but one short date, maybe given last.
Page number 7,
so
Lord.
here for 2 it already become infraction.
Lordship, 2.
Hard to start that. But that one what it for
And 9, my lord.
Nine.
9.
Can Lordship be 7, Lordship?
7. So today is 31st.
but if not read then what will be purpose?
Last chance, I am writing, though not in the order I am writing.
Because it is a case of 412 and all. It is habitual.
Lordship.
That is
Obliged, Lordship.
May I please, Your Lordship?
Yes.
The petitioner has already in interim and the statement has already been recorded, my lord. And FIR is page number 16.
Oh, already Lordship, the main
Main
accused
accused already
he has
granted
already been
bail.
granted bail Lordship.
I have the copy, my lord.
He has appeared Lordship. If Lordship kindly goes to the FIR also. It relates to Lordship forging of the signature of DFO Lordship in a bill Lordship.
for the signature of
DFO on a bill Lordship. And the bill was in favor of the co-accused Lordship, whose bail has already been made absolute Lordship. This present petitioner was the
At the relevant point of time,
he was
the
forest
range officer at the Chonari division, my lord. Now he is posted at, my lord, Dumduma division. But at the relevant point of time, I was the forest range officer. I have no allegation.
forest range.
Range officer. Otherwise,
But election of forging signature of whom?
DFO Lordship.
DFO.
DFO. On a bill Lordship. On a bill which was for in favor of the co-accused Lordship, that is
Bornil
Bornil
Buragohai,
who has already been granted final bill. The present petitioner is the
Kind of other role played by the president.
the role is Lordship, the bill which was in favor of the co-accused Lordship. The signature of the DFO was obtained Lordship by fraudulent means Lordship. This present petitioner also put his signature Lordship because his signature was also needed in the bill for passing of the bill. So when according to his statement, when he put on the signature of the DFO was not on the bill. Subsequently, the DFO's signature was forged and put on the bill Lordship. He has denied his allegation. And already Lordship, the bill on whose favor it was done Lordship, all those activities, he has been granted interim final bill Lordship. Final bill. Lordship kindly goes through. It will clear up the matter Lordship.
or of court or or that but it that that at up of after object but at but that 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 is that uh, path of that that the efforts for from it but 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 when oh my but it of uh but the but and what the that or but pardon or or
Public.
Please, Your Lordship. My Lord, is a one tripping, my Lord. My Lord, in the FIR itself, she has mentioned that she contacted him all over phone, my Lord, and accordingly he came to discuss regarding another FIR, my Lord. Thereafter, my Lord, she, my Lord,
another affair
yes, my Lord, she want to discuss with him, my Lord, with the petitioner regarding another FIR, my Lord, which has been lodged in the Jorhat police station, but same was not registered, my Lord. Accordingly, she want to talk to him, and accordingly, after contact of her phone, my Lord, he came to her house to discuss regarding that affair, my Lord. After that, my Lord, she alleged that when her brother and mother has returned from market, then he came out from her house as a normal general people, my Lord. If anything happened, my Lord, he obviously tell her brother or mother to catch him, my Lord, but she has not doing any such things, my Lord. On the next day, she has lodged the FIR, my Lord. My Lord, in other hand, my Lord, she alleged in the as contents in the mentioned in the FIR as her, my Lord, it attract the offense under section 354A only, which is bailable offense, my Lord. But no any other sections has been attracted as registered under section 354B, 376, 511, and 506, my Lord. Here, no any allegation has been made regarding
where is the affair
FIR, my Lord. Translated copy is at page 9, my lord. I have typed the vernacular also at page 11, my lord. May I read, my lord?
Why she want to talk if the present petitioner is a police officer?
No, my lord. I don't know why she want to talk to him, my lord. That is the case of honey tripping, my lord. Nothing else, my lord. Otherwise, my lord, I am the petitioner is not an police officer, not any judicial involvement is there, my lord. Why she want to talk to him, my lord? There is no reason to talk to him regarding any affair,
He is the
etc.,
person
my
of
lord.
Last Jana.
Yes, my lord.
Oh, that's why.
My lord, that is different because, my lord, he is involved in social activities, my lord. But he has nothing to do with affair, my lord.
Also, there is a
That's okay. So that step for the procedural from inside. And he dragged me. When I tried to shout, gag her, my mouth or whatever. That's the big. And he touched my private part. But why? After there, that's so there he has already committed rape. But I don't know if that's the
lots will kindly go to 164, lots will kindly go to the
164.
yes, lots I've given the one. So there's also I've already put one more flag before the 164 lot.
WhatsApp message is sent after the incident.
My lord, what is in the 164 statement or any other things, I don't know. But thing is that, my lord, if she has mentioned in the 164 statement, that is afterthought. Because, my lord, if such a serious offense has been committed, why she has not mentioned in his as a her, my lord? She has,
She has done.
my lord,
What she has done.
regarding 376 offense of 376 C54B, my lord, that,
This is 511, not 370.
yes, my lord, 511. But before that, 354B has been incorporated here, my lord. But nothing has been mentioned regarding that, my lord. Only she mentioned that she dragged her to or raped her. But it doesn't mean, my lord, attempt to rape or etc., my lord, because elements must be there, my lord. Elements of section 375 must be there, my lord. Nothing has mentioned or found there, my lord, from the FIR, my lord. From the FIR only attract only 354A, my lord, if I believe it as Toto. M Sri Kamala.
M Sakya.
Yes, my lord.
The name is not.
But I have filed, my lord, by mistake.
But, oh, but, okay. That type, comma, okay. I, what, that type, but the that that but that why that why what what Is that it of what of of but are rather that did not at the time of your petition stand
Pleasure.
May it please your lordship. In this case, lordship, we are required to file an additional affidavit, lordship, to bring into record some medical documents,
medical document.
lordship, because we have
It's a
taken
transfer petition.
lordship,
Transfer petition.
we have taken a ground, a medical ground. We have sought for the transfer, lordship, but we have not annexed the medical documents at the time of filing of this petition, lord. So,
And a transfer is sought for the medical ground.
lordship,
No, so far
Yeah,
now,
yeah.
my lord concerned, he is he has sought for transfer on the ground of security purpose, for security purpose, because he cannot go and appear before the court at North Lakhimpur because of security, because he has fraudulently misappropriated some money from public on the plea of
So
supplying.
now case is pending in which state?
It is not admitted. No,
No. No. It's a transfer petition.
transfer petition.
If it case is pending, where it is pending?
Their cognizance has been taken, I think.
Where in which
the additional CJM Lakhimpur, lordship.
and you want to get it transferred?
From any other court to Sonipur or
yes,
nearby district court.
Instead of you want to get it transferred to Sonipur or any other?
Or any other.
Search sheet has been submitted, but summons have been issued. First appearance is yes.
Right. Yeah.
One thing, Lord, in this case, the informant is not made part of it.
It's a transfer petition. Why have made part?
Here case, Lord, he has also some, because he is the victim.
Then we will file an IA also, lordship.
Why get a victim or the informed party in fact?
Lordship. So I will file an IA, lordship.
Because we have their problem also.
Lordship.
Yes.
But that's what. But at some point, but what the but after
Lots. Oblige. May I please, Lordship? This is for passing of a complaint case, Lordship.
Well, this is not forest department case, I think.
Yes,
Forest
yes.
department, no.
Yes,
Hello, standing council, standing council copy this up.
yes, sir, they appeared also. Name also shown in the cause list.
yes, name is shown it.
Forest department, veterinary department also there. Veterinary department has filed their affidavit also, Lordship.
21, yes, name has been shown. But
Allegation is that they have petitioners have constructed some veterinary complex over forest land.
And the husband department is also there.
Yes, sir.
Animal husbandry veterinary department is also
Yes, sir. They have filed their affidavit also.
stairs maybe.
Yes.
Huh?
Yes. M. She is the standing counsel for animal husbandry and veterinary.
They have already filed there.
Yes.
Mr. Gogoi standing counsel. Forest.
Forest.
It's not
Okay. And since perhaps one interim order is operating, so let it come up for admission. I will inform Mr. Digogo.
And
what's it for operating?
My line of defense says that stay order is there. I think.
Stay order
Stay
is
there.
yes. 20 by order dated 28 of June. Stay order was issued by this
28
order.
of June of 2015.
24. 24, 20, 23. 23.
Sorry.
28 of June.
28 of June.
Hey, phone number.
So one criminal division was
Yes,
pending 5 2020. That will stay.
while conducting the complaint case, the judicial magistrate committed some procedural irregularities, and the new judicial magistrate, after joining, find out that irregularities, and accordingly he referred the case to the session judge, and session judge registered a criminal revision petition and retained the or complaint case records with him. And at this stage, we have approached this honorable court, and this honorable court directed to stay the proceeding of the criminal revision petition.
So now how it will help staying the case?
Because the session judge called the complaint case to his table, and accordingly he stayed the now the case is going on in the session judge court. There is the record is not in the criminal court. Complaint in the judicial magistrate court, because lordship may come to case number.
Okay, because we are not getting the matter, we are not going to submit matter, but I'm asking it for my head. So now criminal division 5 there, finding some irregularity committed by the magistrate.
Yes.
That was filed.
Yes.
That was filed by whom? By you.
No, lordship.
No.
While in the complaint case which was going on before the judicial magistrate, the judicial magistrate committed some procedural irregularity. She has framed the charges without taking evidence before framing of charges. So accordingly, subsequent judicial magistrate, he has transferred the case to the session judge to see whether the procedural lapses was there or not. And the session judge, after perusal, find out that there was indeed some procedural irregularities, and accordingly he registered.
That is on the basis of the complaint of the judicial magistrate that revision petition was registered.
Yes, sir.
Your allegation is 200 statements are not recorded. Before recording 200
yes,
statements are
not recorded.
That
And
is not recorded. That exemption is there for government officials in complaint cases. Government officers are exempted from statement before charge. examination report charge is one of exempt government offices. So far, complaint case by the government officers are concerned.
Lordship may come to page number
So-
42.
We are not going here.
And Lordship, by order dated 4/5/223, the scan copy of the case record was called for
4, 5,
23. That was not
This we
received.
have received. Scan copy. 4, 5,
23.
20.
Yes, sir.
Not received it.
Not received.
Art.
AD showed.
The audit appeared on behalf of but and the affidavit is also right for the part. But 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 one the first part that on the I ordered put the scan of record was called for not not the of God can that record after
My lord, since my lord, a fix that may be given because the order is operating. In last week, 30th August, 30.
Interim order to be continued. Obliged, Lordship.
Earlier also none appeared.
44
Transfer.
not appear not appear
On 24/3 none appeared. 12/6 none appeared.
yeah this state but let the state not
It's all pending. Why?
2018
2018 matter.
state operating not appearing can both of
Where stay is there, Malat, not mentioned in our petition.
so state not
Then it can be closed, Malat. 2018 matter. Perhaps it is already become infractual.
record that the just that been last 5
It's closed, my lord.
Yes.
Lordship, actually, we have taken steps against respondent number 2 several occasions.
It's still awaiting.
We have taken it through the OC also, Your Lordship.
For it, yes.
কোন থানা কোন থানা আছে
School, it is 1999 or
Nine-
FIR is lodged in the year 1999. Charge sheet was filed in 2014. Cognizance taken in 2018. The limitation was of 3 years. Your Lordship.
File line. Legal service, no?
Respondent number 2.
Yes, case is of this, it's of 2009.
We
Yes,
have
yes,
filed it
no,
in
the
19.
file is not available with us today. I have to inquire, my lord, in our office.
As per the last report, that is on 97 report, service report, the effect of not from Borolo, they have taken step.
Currently, it will be Vorolumukh.
Huh?
Presently, it will be Vorolumukh, but before, when the FIR was lodged in dispute PS.
So,
In the year
But
1999,
here it is from Borolo.
the address comes under Vorolumukh now, presently. Your Lordship.
no.
The FIR.
Officer,
The address is of 80
80
Road.
Road.
Guwahati. Presently, it will be Vorolumukh. That time, it was under dispute.
I am not.
Address is of 80.
There are lots of
Transfer or not?
steps that have been taken by many occasions,
For PS
it did not return, in fact.
729, original dispute PS 729.99, no? এইটো পিছত চেঞ্জ হৈছে নেকি Okay. 2869 কিন্তু এটা স্টেপটো ঘৰলোক ডিছপ্লটে ল'ব লাগিব বাট কিমান এই অফিয়ে ল'ব ন
But order is there.
এটা এখন আমার তুই এখন ধরলাম উল্টা at that point of time it was peaceful.
What there is the order 39 for the 2020. Of that authority that have been served, reported or not for it noted the reported by the FIR for not half of MKD bills on 25/7/1999. The new law address is available. AD premise it is directed that the learned detective for the state respondent number 1 will be presented for number 4. What? We are directed to representative for number 4. It was ordered dated T9/2020.
He is not the police personnel. Sanjay Kumar Mehta.
So I have seen this not
And now this MKD films, whether it is available, message MKD films, whether it is available or not.
Okay, there is
Again, you
subsequent
see on 9/10/2020, another order is there. Where is the petition number 2 is represented by the learned counsel. Petition so and so. State the respondent number is represented by learned. Oh, you are for 2.
No, we are for one. We are
You are
first
for
step
one.
for one.
Go by the record then. What is there? But whatever, step 2 on record number 2 is not. Have to go to present address, dedicated address.
So this is the address available in the FR also.
This Sanjay Kumar Mehta, son of Prince, Mr. Captain. 80
এটা কাইন্ডলি এটা
different.
এটা কপি এটা দিতে কি হবে
Copyright violation. Matter is related to copyright violation.
copyright violation. Then Marat, now this direction may be given to the active volume of case because this access is a volume of whether this person or not we will communicate to the volume of case and can provide it. Malat again, Malat, so that order will communicate with the Malat's order and along with the petition copy will whether actually this now this presentation actually in the place or not because it's all pending case in 99 whether that MS
MKD print.
MKD print is available or not at present under a volume of don't know Malat. So volume OC volume
Do you have any idea whether it is regarding the presence of the MKD print?
No, we also don't have because we have taken steps several times, but it has not been started.
no to effective Malat service Malat will communicate Malat to the OC volume of case. Origin cases of dispute. Now the address is volume. So OC volume will do the next Malat. But has to be reflected in the order Malat will. No? Report.
From that was ordered number and contact number or method
And if found Malat, if found Malat, then notice to be start. And Sanjay Kumar Mehta one name given, whether he is alive or not since 99.
this matter when it can be listed, Mr. Parch.
Malat 27th of August.
For another 5 months.
Service not completed.
This one number 2.
My lord, service is perhaps complete, my lord. Kindly see the Lodging order, my lord, dated 8/4.
So now you are appealing for who?
I am for 3, my lord. That's one number
8/4, no? Yes. Lodgement of course order is there, my lord. Service is complete.
Complete in respect of plea, my lord. Not
No, no, the left is open. Three complete is enough. No, no, two complete, sir.
So you are for 3.
I am for 3, man.
Which seems to be completed as per Lodgement report. So service is
Yes, ma'am. So, my lord, there was two orders, my lord. Kindly see the order dated.
Matter may be taken admission, my lord. The hearing is required.
going to get
My lord, the interim order is required. That's why, my lord, I'm
No.
to be taken up at here or taken. Just edit for that one number from order of order plus order
P1,
order of lodge of court. The- and the sentence was put that on one.
my lord, kindly have a look, my lord. The order dated 23/1 and 16/2, my lord. Order, my lord.
Whose order? It's court.
This is our report's order, my lord. That my lord, on the completion of service and the report of the CJ, my lord, interview will be considered.
For if you wanted to fix it, I can.
My lord.
Wanted to fix it?
Yes, yes.
27 we have
My lord,
admission call.
my lord, maybe 29, my lord.
29.
Yes, my lord, 29, my lord. The hearing day is short. It will be there, my lord.
In that
129, my lord.
Lordship, with respect to item 45, your lordship, there is an interim is there.
interim was there.
Yes.
Okay, we'll communicate.
Maybe lordship, my lord, this leave petition is filed, my lord, for checking the file and appeal. The equital against the respond number 1, my lord, discharge from the charge, my lord, for the leave petition, my lord. Appeal against the equital, my lord.
Appeal against
Equital, my lord, yes. So leave petition is filed for that, my lord, purpose, my lord. Yeah, under NI Act, my lord. So,
In the leave petition notice may be issued.
this may be go, my lord.
In the leave petition. Yes,
my lord.
NIAC, my lord.
NIAC, my lord.
There is a formal party on.
Formal
You are
party.
formal party.
Yes, my lord.
If we should take steps with a short bit and then speak it on after approve it.
Yeah, well, only the date may be given. my lord.
It's a case of date service completed. It's a
Hello, Blay.
May please, your lordship. But this service, actually earlier not taken step, lordship. Today we have taken the steps.
taken in IA.
IA,
Not
lordship.
taken step.
Today already have taken
They have already taken step.
to the respondent number 2.
As per so dated 24 5
দিলে কোন
Next week on the corner have submitted
কি মানবেন দিলে
that we have already on it. Today you have taken
Yes,
we
ma'am.
have already-
এটা আলিয়ার লিস্ট হয়েছিল নাকি
to take some time this stuff to keep and then for the I gave what is it?
I maybe
I in B.
correction maybe
Maybe some correction I think.
yes this dispose of case
Yes, both of them. Most probably correction is not required now. They are absent. And then go not most probably I think not every according